Turn it on. Testing 1, 2, 3.
Testing, testing. 1, 2, 3. Hello, hello. Testing, testing. Okay.
Testing 1 2 3. Testing 1 2 3. Testing 1 2 3. Testing 1 2 3.
Oh. Test 1 2. Test 1 2.
All persons having business before this honorable court are admonished to draw near and give their attention. This court is now sitting. God save the United States and this honorable court.
Good morning, everyone. I'd like to, before we begin, thank SIU Law School and Dean Davidson for hosting us here this morning for oral arguments. You have our gratitude. We're very happy to be here, and thank you for being such gracious hosts. Before we begin this morning, I would also like to remind everyone about the federal court's policy against broadcasting. There is no photography and no broadcasting of any kind allowed in the court proceeding today. We will take one photo for posterity before we begin so that we can record this event both for the law school and for the court. All right, and with that, I'll call this morning's first case for argument, and it is Christine Simmons versus J.B. Pritzker. Ms. Shipp.
Good morning, may it please the court. Carissa Shipley here on behalf of Christine Simmons. As I'm sure the court knows, this is a case regarding the property rights of disabled children. The district court saw fit to dismiss our case based on mootness, which was in error. The other major issue within this case relates to the exhaustion requirement for administrative remedies for children under the IDEA. There are a few other smaller issues, but I believe that the biggest issues here are those mootness and exhaustion arguments. The court erred when it dismissed our case for mootness based on the fact that the children's property rights to a free, appropriate public education there was a complete issue with those rights.
Before we go too far down that road, I want to confirm something. TS is the only remaining plaintiff in the case, correct?
Yes, that's correct. And TS's parent, Christine Simmons, who also brings the case individually.
Okay, so but the case was brought by Ms. Simmons, not by TS, correct?
It was brought by Ms. Simmons individually and on behalf of TS.
On behalf of, so
yes.
He's over 18, correct?
Yes.
And he's graduated.
That's correct.
Has he redelegated his rights to the IDEA?
No.
How can she represent? How she was
So she has standing under her own rights as a parent under Winkleman versus Parma. So
how does she have standing for any kind of conjunctive that is sought here, which would be relief in terms of the education?
So she doesn't have standing for prospective relief. We believe she has standing for retrospective relief.
So most of your claims are prospective. Do you agree since she doesn't have standing that you can't continue to pursue those claims?
Yes, on her individually, we did ask for a class certification, and this was prior to when TS graduated.
How would she be an adequate class representative if she doesn't have standing to pursue those claims?
At the time the case was filed, she did have standing to pursue those claims.
But she doesn't now.
That's correct.
So you agree then that the only claims, because there was never a class that was certified, it's just the individual claims in TS. The only claims that are before us today are for any kind of retroactive relief?
Yes.
In what form?
Nominal damages.
Under what statute or law?
Under the Uzagbanan case.
I'm sorry, what statute or law? Nominal damages under...
No, that would be under the Americans with Disabilities Act and our 504 claims.
Those are coextensive with the IDEA. Those don't confer greater rights, and certainly not on the mother.
Right, they do confer greater remedies, though, even though it is a faith.
But the remedies run to the student, not the parent.
The parent also has separate distinguishable rights.
To
under the
vindicate the child's rights?
Yes, because
It's derivative then. And we back into the problem that Judge St. Eve was mentioning about the student being over 18 and not delegating his rights to his mother.
Yes, the parents' rights had a complete, the parents' rights were also violated. So the parent under the IDEA and other laws, it continues to have a right to participate in the due process portion of the IDEA, and that was also violated.
But there's no damages remedy for that.
So that would just be the nominal damages. And under the Uzagbanon case, I believe it was Justice Kagan who was actually summarizing Taylor Swift, that $1 of nominal damages does represent something. So when there's a complete violation of a right, asking for $1 might seem minimal, but it does represent something.
No, I understand the principle of nominal damages. The problem here is that your client, the mom, had strictly derivative claims. She was vindicating the rights of her son, not her own rights. And so to the extent that the son is now no longer a student and he's over 18 and has not delegated his rights to her, she doesn't have standing to advance them either for injunctive relief or for any form of compensatory retrospective damages, whether nominal or otherwise.
Well, I believe that she does have rights that are separate from her son's, while they may come from his denial of a faith. The IDEA is also very parent-centric. It's not just student-centric. So she had the right to advocate for her child in a due process hearing, and that right was
Well, she didn't invoke those rights, though. That overlaps into the exhaustion problem here, but there was never any attempt to exercise administrative remedies under the IDEA by asking for review of Governor Pritzker's shutdown order and the extent to which it was impacting her child's education.
Right, and we do believe that exhaustion in that case, that those requests would have been futile in the administrative state.
I understand that's your argument about the exhaustion requirement. My point is really more fundamental to that. It's that she did not invoke her right to a due process administrative review on behalf of her son. So there can be no due process concern here.
So she actually did file 3 separate due process complaints, but she didn't complete and exhaust the administrative process.
That's the problem.
Right. Yes, I understand, and maybe she should have gone through that issue, but we don't think that she needed to exhaust, based on the fact that she was denied for example, the notice requirement. She was denied notice that her child was getting a change of placement.
Let me ask you this. As I understand it, then, at this point, you are no longer pursuing the compensatory education or some type of relief damages on behalf of the child. Is that correct?
Yes, the child has graduated and he is no longer a minor.
Okay, so we can take that off the table.
Yes.
So the only thing to pursue are any kind of damages that the mother might be entitled to.
Yeah.
To the extent she is.
Yes, that's correct.
And you said, I believe it was in your motion to dismiss, in your response to the motion to dismiss, that you were not seeking any monetary damages against the defendants. Have you waived that right to seek nominal damages?
No, I don't believe we have. We have that in the complaint, that in several places that we're requesting nominal damages.
Would you agree that the mother, Ms. Simmons, cannot pursue the RICO claim on behalf of her son either?
I think that the RICO claim was based more on a class action and less on Ms. Simmons alone.
But she still has to have standing to bring it. And now that her son is over 18, how can she continue to represent him for purposes of the RICO claim? Because the RICO claim wasn't pled as if they were her rights. It was pled that she was bringing it on.
And I think that, again, her own separate rights give her standing to pursue the RICO claim based on the fact that she was denied notice of the change of placement.
So you agree that she can no longer represent TS to the extent she's pursuing TS's rights, given that he's over 18.
Yes.
And she hasn't been appointed by a court in any kind of representative capacity. So the only RICO claim, to the extent you pled it and it exists, would be her own rights.
That's correct.
You can proceed.
Thank you. I believe we touched just a bit on the exhaustion claim, so I'd like to address that as well. This case their initial brief was filed last January, and in the interim, the Supreme Court decided Perez versus Sturgis, and that case essentially excused exhaustion when a remedy was requested that wasn't available under the IDEA. So our request for nominal damages, I believe that the Sturgis case should now apply to this case, and that this case should be remanded based on the fact that it was dismissed for exhaustion prior to Sturgis being determined.
If I could get some further clarification on the source of law that you're relying on for this claim that your client, the mother, has for nominal damages. It's not a claim for nominal damages for violation of the IDEA.
No, it's
because there's no nominal damages under the IDEA.
That's correct.
So it's nominal damages for violation of her rights under what statute or constitutional provision under 1983?
So under the ADA and 504.
But she's not disabled. She's vindicating her son's rights.
Yes.
And this is not a discrimination claim. And that's what those two statutes address.
So we do think that there was...
She's not being discriminated against, and her son is not being discriminated against. It was an across-the-board shutdown order that the governor issued that closed all schools for all students and families across the entire state.
But through that shutdown and through moving to virtual learning, special education students were denied the support services that they needed. So whereas you might have an average child who can learn virtually, a special education student has those additional services that they have a right to that weren't able to be provided virtually. And that denied them access to education. So while they could perhaps sit in front of a computer and watch a lesson, they don't have the same ability to appreciate what's being said. So
how is that explained? Are you talking about rights of the students, deprivation of educational opportunities to the students? That's not like bring, see that you can't bring them. What's the claim under the...
Sorry, I think we conceded that we couldn't bring it on behalf of the student because...
On behalf of the student, yes. Or the mother, to the extent you're seeking nominal damages, because nominal damages aren't allowed.
Yes, so ADA and 504 claims that we're bringing, as the mother of that student, we believe that her rights were discriminated against because she had the right to be contacted by the school. She had the right for the school to say, we're moving to virtual learning. How can we make this work for your student? Is this working for your student? And she had the right to consider the change of placement and advocate for her child. Right. At the time the case was brought, she held the student's rights.
Right, but we've covered this. He's no longer a student,
Right.
and he's over the age of 18, and he did not delegate his rights under any of these statutes to her. So she's got nothing left. Sorry, I interrupted you.
I mean, I'm getting to the same question, which is, so it sounds like your theory is that the mother was discriminated against because she had a child with a disability. And I'm wondering whether you have any authority, statutory or otherwise, that recognizes a derivative discrimination claim like the one you posed.
No, I don't believe we have any authority for a derivative discrimination claim.
I think you wanted to reserve 5 minutes for rebuttal.
Yes, that's right.
All right, you're into your rebuttal time, so
Thank you.
perhaps this is a good time to wrap up.
Okay. Yes, I'll reserve the time.
Thank you. Ms. Jonig.
Good morning, and may it please the court. Assistant Attorney General Lee Jonig for the state defendants. Based on the appellant's presentation, my understanding is that the only remaining claims in this case are a request for nominal damages by the parent, Christine Simmons, based on alleged violations of the ADA and Rehabilitation Act. So I'm going to focus my presentation on those issues unless the court has any questions about the district court's ruling on mootness with respect to the claims for prospective relief.
Just to include in there, Ms. Shipley indicated she thinks there's also a RICO claim.
Yes, thank you. I will also address the RICO claim. And then counsel for the Ottawa defendants will then address any issues or questions that the court has specific to those defendants. So to start with this question, this remaining request for nominal damages, there's a very simple way for the court to resolve that request, which is that the plaintiffs abandoned their request for nominal damages, which we explain on pages 40 to 41 of our brief, and they do not respond to that in their reply to that the fact that they, in the district court, conceded that they were not seeking any form of damages. And even if the court were to set that aside, nominal damages are not available under the Individuals with Disabilities Education Act, which, and my understanding based on the appellant's presentation is that the only basis for the parent to have a claim for nominal damages is based on lack of notice and other sort of statutory rights that are created specifically by the Education Act. So to the extent that the plaintiff is seeking nominal damages based on that, they're not available. And then to the extent that they're seeking nominal damages based on alleged violations of the ADA and Rehabilitation Act, there's no allegations in the complaint that the parent was discriminated against in any fashion. And so that's another way that this court can resolve the request for nominal damages. So for those sort of two independent bases for the court to rule on that, the court doesn't need to reach this issue of Luna Perez, and whether that the claim is seeking relief for that's not available under the Education Act.
How do you respond to Ms. Shipley's argument that the parents are seeking nominal damages for due process rights, and inability to get proper notice, be able to add?
So those are rights that are created by the Education Act, the IDEA, and the IDEA plainly does not allow any plaintiff to recover any form of damages. It allows other types of remedies, which are no longer being sought here, like prospective relief, injunctive relief, declaratory relief, or even compensatory education. But now it appears that plaintiffs have abandoned those claims for, those other types of relief. So nominal damages for any rights that are created by the Education Act are not available. If plaintiffs were seeking these other forms of relief, their claim would have been properly dismissed because of lack of exhaustion, as the district court held. But unless the court has any questions on that, my understanding is the plaintiffs have abandoned that claim. So with respect to the RICO claim, the plaintiffs contend that a free, appropriate public education is effectively a property right. We explained in our brief why that is not the type of injury that can be compensated for under RICO. But in any event, it's not a right, even if it were sort of theoretically a right that the student had that could, give rise to a RICO claim. It's not a right that the parent has. There's no authority that I'm aware of or that plaintiffs have cited that suggests that a parent has a property right to their child's education such that the alleged interference with that right generates a RICO violation. The plaintiff's RICO claim is effectively trying to get around the exhaustion requirement by sort of dressing up their claim for the alleged deprivation of an education as a RICO claim. And it fails for a number of reasons, all of which we laid out in our brief. Unless the court has any further questions about that, we would rest on our brief on the remaining issues.
Thank you. Mr. Bernard.
Good morning, Your Honors, and may it please the court. My name is Eric Bernard, and I represent the District 140 defendants here. And I just want to take a few moments to address some specific issues that pertain directly to District 140 and perhaps not to the state defendants. And in particular, I'll begin with mootness. Since the filing of this lawsuit, as we indicated in our brief, TS has graduated. And based on this court's holding in Board of Education versus Nathan R., any requests for injunctive or declaratory relief pertaining to the provision of special education services have been mooted as a result of the plaintiff's graduation here. Furthermore, based on opposing counsel's concession here, they're no longer seeking any type of compensatory education services, which takes that off the table. And so ultimately, when you look at the facts that have occurred in terms of the graduation, we believe that moots the case. I'd also point out that there's no reasonable expectation that District 140 will return to remote learning in any capacity. In particular, I'll direct the court's attention to Section 10-30 of the Illinois School Code. That's a provision that was passed in June 2020, I believe, as a result of the COVID-19 pandemic, and it provides that remote learning can only be implemented if two things are present. First, there must be a public health disaster declaration in effect, and second, the state superintendent must authorize the schools to use and implement remote learning. Governor Pritzker's disaster declaration expired earlier this year. As a result, neither the state superintendent nor District 140 has any authority to enter into an extended period of remote learning, notwithstanding the fact that they've been fully in person for 2 complete school years, as well as the current term as well. And so when you consider the amount of time they've been in full in-person learning and their statutory inability to enter into remote learning, once again, we believe that makes the matter moot. With respect to, even if the court determined that this case was not moot, we still believe that plaintiff's claims should be dismissed for failure to exhaust administrative remedies. I believe we've extensively briefed that issue, but to the extent the court has any questions, I'm of course happy to answer any. I guess the final argument I would say is, even if the court believed that exhaustion was not required, we believe, as we set forth in our brief, that plaintiffs have failed to state a claim on all of their counts, and dismissal will be warranted for that reason as well. And so, unless the court has any questions, I will leave it there.
Thank you.
Thank you.
Ms. Shipley.
Thank you, Your Honor. We're asking the court to remand this case back to district court for error made by determining that the case is moot. The violation of the parent's rights was a complete violation, to which she's entitled redress. Also, to remand on the issue of exhaustion given the holding in Perez. I'll also quickly address the RICO violation. The parent does have a property right to the child's education that exists through the child, but that also exists in the parent's inherent desire to have an appropriate education for their child. And when the school district drops the ball on that, the parent is often put in the position to pick it up. Mr. Bernard touched on the merits of the case, but the merits of the case were not determined at the district court level. It was dismissed due to the mootness and exhaustion issues. And so plaintiff respectfully asks this court to remand.
Thank you very much. Our thanks to all counsel. The case is taken under advisement. We'll move to our second case this morning. Elizabeth Alicia versus Cook County and Thomas Start. Mr. DeRay.
Good morning, Matt DeRay for the plaintiff's appellants. May it please the court. As this court, sitting on bonk, recognizes in Henry, individuals in custody retain Fourth Amendment right to bodily privacy. Indeed, all individuals, regardless of whether they're in custody, should be entitled to a basic level of respect for their human dignity. In this case, however, the Cook County and its sheriff deprived plaintiffs and other detainees of that basic human right when it recorded them using the toilet in its holding cells. Nevertheless, in the proceeding below, the district court held that defendant's conduct was legally permissible, and for the reasons I'll explain, that decision should be reversed.
Before you jump into the merits, a question about standing and which of your clients has standing to sue, because as I understand the record, only one of the plaintiffs can identify the holding cell that she was held in one of the Cook County courthouses that had a security camera that was positioned in such a way as to be able to see behind the barrier.
Yes, Your Honor. So I understand the question, and Your Honor's right that there is there's the record is unclear as to several of the plaintiffs, precisely which holding cells they were in and precisely which holding cells were recorded. There is no dispute that at least one of the plaintiffs, Plaintiff Alicia, was in a holding cell that was recorded, that the toilet area is visible. So as far as standing For the case at large, I don't believe that's an issue. There may be individualized issues with respect to some of the other plaintiffs. However, as noted in the briefing, there were some issues with discovery where we were doing class discovery and never had a chance to do discovery on individual claims in connection with the motion for summary judgment.
Why would that be class discovery? Assuming your representation is accurate, standing of a named plaintiff for adequacy of representation purposes is squarely within classification discovery.
You're right, Your Honor. So the issue is twofold. Number one, it was the scope of discovery, but the other issue was that, you know, towards the end of discovery, there were documents and photos and videos that were not turned over towards the end of discovery. Plaintiffs moved to compel 3 different times. Those motions, the first 2 motions were granted in part, at least with respect to the documentation and photographs and stuff that would have allowed the plaintiffs to identify the cells that they were in and identify precisely where, what cells had cameras that would have allowed them to determine with certainty precisely where they were held. But at a certain point, the court ordered that discovery was closed. We asked, notwithstanding that because the motion to compel had been granted, that defendant be required to produce that information anyways, and the court flatly rejected that request. So
you agree that if Ramos, Meadows, and Urtia, those named plaintiffs, there's nothing in the record that supports that they were actually in a system that had a camera in it that picked up images of anybody using the toilet.
There
only Alicia was identified.
So far in the record, to my knowledge, that is correct, Your Honor. That doesn't mean that they weren't. I just want to be clear. There might not be something.
Here on appeal, and the question is standing. So without that, I don't know how you have standing as to those.
I understand your Honor's standing point. I guess what I would say is that one of the remedies that we asked for, to the extent that, you know, there are just open issues of fact like that the case be remanded for further discovery on those issues, and if it turns out that there isn't standing for purposes of summary judgment, that ruling could be appropriate. But, you know, at this point, our contention would be that because discovery hasn't been completed and that remains an open issue, that if further discovery was right now, the issue of standing is the allegations and the complaint. I understand that summary judgment was decided, but our point is, if summary judgment had not been reached and we were allowed to do discovery, they would have had standing, at least for purposes of getting to this point in the trial, because those allegations were made in the complaint that they were recorded. But your point's taken, Your Honor. But in any event, plaintiff Alicia unquestionably does have standing, because those are not concerns for her. So I'll continue with the merits, at least with respect to her.
And with respect to her, can you provide us with your best argument as to why the plaintiff Alicia has an objective expectation of privacy of using the toilet in the holding cell?
Well,
I understand that there were barriers between the toilet area and the rest of the holding cell, and that's where she was in. But what about with regard to the objective aspect of the application?
Well, Your Honor, on that point, I would say, there's plenty of case law cited in the brief. There's plenty of decisions. And what I would say is, when it comes to the objective expectation of privacy, it's really based on what society would view as being reasonable. And frankly, as members of a civilized society, as members of a community that we understand the issues with incarceration, we understand the issues and the needs of punishment and deterrence and all that. I would say that even still, as a civilized society, people would be willing to recognize, society in general would be willing to recognize that individuals have a right to privacy while using the toilet.
Would that also be true not only in holding cells, but say in the jails and prisons themselves. So in other words, to the extent is your argument that to the extent that currently in prison, there is no barrier in the individual cells between a toilet and the prisoner's living quarters, that somehow violates their Fourth Amendment resuscitation privacy rights?
Well, Your Honor, and this is one of the issues I was going to get to. When it comes to the reasonableness of the search and to the factors that are considered as far as the objective expectation of privacy, again, there's other factors that come in as far as what the security interests are, how frequent the observations were, and
I think, counsel, that goes to the reasonableness of the action, the reasonableness of the search, the extent of the search. But the first question is whether or not there is a reasonable expectation of privacy, right? That's the first prong of the test. And so to establish that, you have to establish the subjective basis of privacy and the objective. And I'm trying to ask you, again, with regard to the objective, where does that come from?
So the reason that I mentioned those other factors is because the objective is based on society, and it's based on what ordinary society members would deem would be reasonable. And what I'm saying is the reason those other factors come into play is because it's one thing for a person who is in a prison setting that has a toilet area that's open to the public, where there's not constantly a camera monitoring them. There's not constantly a guard sitting outside. They're only sharing a cell with maybe one other person, and they have the ability to make a conscious choice as to whether or not they're going to use the toilet. They have the ability to shield themselves. They know where the lines of sight are, and frankly, at that point, they've already been tried and convicted, and there is different security interests, and there's different justifications. Whereas when you're in, so I understand what Your Honor is saying as far as would the reasonable expectation, would it be reasonable in a one type of cell versus another type of cell? I guess what I'm saying is that all these contextual things all depend as far as what society would deem would be reasonable, and the objective expectation of privacy. That's not to mention that there were also barriers up. There's there's a guard at ground level that is shielded from those things. So I would say for all of those reasons, not only the subjective and the objective kind of go hand in hand here, only because they're all factors that both plaintiffs individually, when they were making the choice to use the facilities in the holding cells, but also as society in determining what a reasonable expectation would be, would also consider those factors as well.
Does the prison's policy play into the objective reasonableness? Namely, they're directed not to look at anybody in a state of undress, and really reinforces that any viewing here was inadvertent.
So, Your Honor, and I understand I'm going to my rebuttal time, so I'll try to be brief just to address your question. Those policies, I understand that on one hand it could be viewed as these viewings were inadvertent or occasional, but on the other hand, it shows how unnecessary it was to actually record people using the toilets. It shows that there is no security interest to actually observe that part of the prison cell without obscuring it, without making any sort of accommodation to protect the privacy while using the toilet. So I'll elaborate more on that in just a moment, but I would say that those policies demonstrate that this policy was unreasonable and violated the expectation of privacy. So with that, I'll reserve my time. Thank you.
Thank you. Mr. Burns.
Good morning, and may it please the court. Daniel Burns on behalf of defendants Cook County and Thomas Dart. Detainees have failed to put forth evidence that they were subjected to a search for purposes of the Fourth Amendment. Absent a search, there can be no Fourth Amendment violation. Moreover, the detainees had no reasonable expectation in the courthouse holding cells, where they were placed with other detainees following trips to and from court, and each detainee testified under oath that they saw cameras present in the cells. To the extent this court finds that the detainees were searched and that they had a reasonable expectation of privacy, any search was nevertheless justified by significant institutional concerns. The district court properly granted summary judgment in favor of the defendants.
Is it your position that the videotaping was justified by security reasons or something else? You seem to take different positions during the litigation.
So, yes, we monitor the holding cell. That's our interest in holding the cell. It's not
the
to
toilet area in particular. Is it your argument that there's a security reason to capture video in the toilet area, or that just inadvertently got videotaped as part of monitoring the cell?
It was inadvertently monitored while monitoring the holding cell itself. Correct. The reason, and also too, this.
So are you saying that it's your position now that there is no governmental interest in not blocking out the area of the holding cell that has the toilets? Because I understand that there's some evidence that in some courthouses, right, there's like a black patch, or they somehow kind of blur out the area where the toilet is. So are you saying that that system would be sufficient to satisfy all of the governmental interests in monitoring the holding cell?
So first, let me say there is no interest in monitoring detainees using the toilet. That's not what we're doing. It's to monitor the cell, and inadvertently that there is some, not all, some cells you can see the toilet area. As to your question regarding blocking that out, each facility is different, and that's up to determine what is necessary to provide institutional security, safety, at the same time balancing rights of detainees. So now we have cameras in cells that are differently configured, different age of buildings, so they're put in a way where we can monitor the cell itself. So for example, the black boxes, that was a decision made based on the facility itself, which wasn't a part of the complaint here, as the plaintiffs allege courthouse holding cells. I believe the black box was at the Maywood 24-hour lockup facility, which was separate from what is alleged in the complaint. But in terms of the Fourth Amendment search, they have not put forth any evidence that they were even subjected to a search. They pretty much base it just on speculation. The fact that they were in a cell, that there was cameras, and they used the bathroom, they extrapolate that to say that they're somehow searched. There's just simply no evidence of that. The search policy is written. It allows.
Did they ever get evidence that given that the video recording is destroyed after
30 days, Your Honor, but
how would they ever get evidence that they were actually captured?
Well, they could, take certain depositions to find out if someone admitted to seeing it, if there was an incident that occurred in the cell and camera footage was preserved. They could possibly demonstrate it that way if they were in the same cell when something happened. But
I'm not sure why you're framing your argument as a sufficiency of the evidence argument as opposed to a legal argument that security cameras in holding cells are not a search, and if they are a search, they are reasonable because of the security concerns that exist in every inch of any jail or prison property. So this is not a sufficiency of the evidence kind of a case, except to the extent that it bears on the question of standing. But beyond that, I understood your argument to be a legal one, that as a matter of law, the use of a security camera in a holding cell that happens to incidentally capture some area behind the screen, the privacy screen for the toileting facility, is not a search as a matter of law, not as a matter of fact.
Sure, correct. Yeah, and I was pointing that out, that there's nothing to even indicate that these particular individuals were also.
That's a factual argument. Let's focus on the legal argument.
Sure, and first, the detainees here have no reasonable expectation in those courthouse holding cells. They're brought in, they go to court, they come back, they interact with different people. We don't know what happened, contraband, etc.
But Mr. Burns, I guess following up on Chief Judge Sykes' question. Why wouldn't a camera recording of a holding cell be legally a search?
Because there's a very good chance, in fact, most of the time, they're not even viewed. It's destroyed after 30
So
days.
If the government comes, puts a camera in my house and records us, but there's a policy, and maybe the government viewed it, maybe they didn't. You're saying that that would not constitute a search because of the possibility that it might not be viewed?
Well, first off, obviously, Judge Lee, you're not a pretrial detainee. So obviously, that factor reduces any reasonable expectation.
But we're not talking about, so that's one prong. We talked about that, right? So the first prong is there reasonable expectation of privacy? One part, the next step is, was there a search, right? And you're saying there was no search, that this would, as a matter of law, there was no search because recording the holding cells cannot in itself ever constitute a search legally if it might not be viewed. I think that's your argument, right?
Yes.
And so my question to you is, well, if the government puts a camera in my home and it has a policy saying, well, if we need this later, we might take a look at it. But, unless someone needs it, we'll destroy it in 30 days. So you're saying under that actual scenario, that hypothetical, that the government recording the goings on in my house would not constitute a search?
Well, Judge Lee, in your scenario, obviously the home has obviously been protected under the Fourth Amendment. There's plenty of case law showing how that is a source of protection, where here this is a public space. There's other detainees held in these holding cells. These are individuals that are going to and from court. So in your scenario,
but so certainly you would admit, though, that if a guard came into the holding cell and did a strip search, right, of a detainee, that would constitute a search.
A strip search, sure.
Right.
Yes.
In the holding cell.
Yes.
So it's not the fact that it's in a holding cell versus a house that prevents it from being a search, because guards can do searches in a holding cell, right? So my question is, what is it about the recording that takes it out of the category of a search?
Well, again, it would be the fact that it's not viewed, and also, as this court has held, that to search means to look through something, to find something. This was incidental recordings that aren't going to be viewed unless there's an
argument was inadvertent nature of this, an incidental nature that took it out of the search based on some of our precedent.
Right. It's the incidental nature that there's no intent to search, that these cameras.
It has nothing to do with subjective intent.
So why
A search occurs when the government violates a subjective expectation of privacy that society recognizes as reasonable. Let's assume there's a subjective expectation of privacy. The pivot point in the argument ought to be that there is no objective expectation of privacy in a prison cell, because that's in fact what the Supreme Court has held and what we have held, and nothing we said in the Hewlett versus Henry case about strip searches eliminated that doctrine, nor could we. The Supreme Court has said that prison cells and jail cells with pretrial detainees, there is no reasonable expectation of privacy as an objective matter.
Correct, yes. And, obviously the presence of cameras that everyone sees, further supports that.
Right. So if a guard walking by can see into a corner of the toileting facility in the holding cell, that's not a search any more than a camera that's fixed on the wall that can see into a corner of the toileting facility. Part of the cell is a search. Legal question, not a factual question about who intended what.
Right.
How many times the camera feed was viewed by a guard who was in the control room. None of that matters. This is a facial facial kind of a challenge to the use of security cameras in holding cells.
Yes, held by pretrial detainees.
Okay, now that I've made your argument for you, maybe you'd like to kind of get back on track.
Well, I'm not sure I can improve on that anymore, Chief Judge said. But again, and to the final, even if the court considers this search and that there is a reasonable expectation of privacy, is justified by the needs of the facilities and the sheriff. Specifically, in probably two examples work best. If, for example, there is an allegation of misconduct leveled against a guard, we can go back in the camera footage, see what happened, and that can inform any disciplinary proceedings, any criminal proceedings that may happen. If there's a medical emergency, we want to know what happened, we can go back, pull the camera, and find out what happened. And that serves a very strong security interest for Sheriff Dart and Cook County, especially in the detainee holding facilities.
Right, because the security risks don't stop at the bathroom door, for lack of a better way of putting it. Security risks can occur inside of the toileting facilities as well, insofar as they relate to weapons, contraband, other things that can be smuggled into the jail.
Absolutely. And, you know, the fact that they may be searched before doesn't diminish that, because they go out of the cell into court, encounter other people before they come back too. So for all those reasons, any search, if the court finds a search, again, it was reasonable under the circumstances here. If there are any further questions, I ask that you affirm the judgment of the district court.
Thank you.
Thank you.
Mr. Duray.
Thank you. So I'd like to address first what Judge Sykes just mentioned. So I understand the Supreme Court's holding at Hudson and some of the prior precedent of this court, but I do want to point out that in Henry, this court explicitly noted that Hudson left open the question of whether and to what extent prisoners maintain a right of privacy in their bodies, and favorably quoted from the Sparks case that Hudson does not establish that the interior of one's body is as open to the invasion as one's prison cell. So on that point, I would say that while I understand that the scope of the Fourth Amendment within the context of a larger prison cell is established by Henry and other precedent, this court in particular, but I don't think that decision applies to the bodily privacy issue that we have in this case. I on that point, so the excuse me. The next thing I want to point out is that, if there was simply the fact that someone is in a custodial setting where there is surveillance, if that were sufficient to extinguish any right of privacy, including bodily privacy, then decisions in Henry and Canadian and other cases like that, where courts have found that violations of the right to bodily privacy are Fourth Amendment violations.
In the context of strip searches.
I understand, Your Honor. It was in the context of. It doesn't involve strip searches, but it involves, conduct that is equally as degrading and demeaning as a strip search would be. There's plenty of authority that talk about there's plenty of cases that talk about how the same interests that are implicated in strip searches are implicated when an individual is trying to use the toilet. The next thing I want to note is that there is authority talking about one can create a temporary zone of privacy even in a place where there may not be an expectation of privacy as to other types of invasions. So that was the Takeda case. There's also the Katz case where the U.S. Supreme Court said an individual in a closed-in phone booth may not have an expectation of privacy from being visually observed, but he does have an expectation of privacy against being audio recorded. So
those are not prison cases or jail cases.
I understand, Your Honor, but
they contextually very different. So those general principles that apply to society at large do not apply here.
Your Honor, I understand your point, but I think that they're still analogous to the position.
Not even close.
The other thing I want to note is defendants here admit that their observation was inadvertent. So they're saying that there was no need to record people using the toilet. There was no need for them to have done this at all. Yes, there was a need to monitor their holding cells, but as Judge Lee pointed out, that they have the ability to do that without invading, people's privacy in such a demeaning and dehumanizing way. I on that point, I do want to point out that, in cases such as Johnson and the other authority that's cited in the brief talking about incidental viewing being acceptable, though all those decisions were based on a weighing of the needs and the justifications and the scope of the search versus all the other factors. Whereas here, we have defendant explicitly admitting that there was no justification. So even though those cases say that one thing is appropriate, doesn't necessarily mean that in this context, the similar thing was appropriate. So for those reasons, Your Honor, and the reasons set forth in the briefing, we ask that the case be reversed and remanded as we requested. Thank you.
Thank you. Our thanks to all counsel. The case is taken under advisement, and we'll move to our third case this morning. United States against Slater. Ms. Jacobs, good morning.
May it please the court, Michelle Jacobs on behalf of the appellant Arturas Slater. This court should vacate Mr. Slater's sentence and remand with directions to enforce the government's waiver of their sentencing objections and require that the sentence be the sentencing be redone or reimposed using the guideline calculation from the initial pre-sentence report. This was an unequivocal waiver. And I don't say that lightly. I don't like to use the words clearly and unequivocal and all that kind of stuff very much in appellate work. But I don't think I've seen a clearer waiver by a party than we have here. The government filed a written submission to the probation department indicating, and this is the least of the waivers, that it had no objection to the pre-sentence report. It then filed a written submission where it said it agreed with the drug weight calculation used in the pre-sentence report in regard to the edibles. That's waiver. And then when you look back in terms of the sort of history of the case, it took the position over and over and over for a year.
If I could ask you though, with regard to the question of waiver as applied to the government, eventually though, before sentencing, before the final judgment was entered, right, the government said, we reconsidered our position. And, under Rule 32, it says we should be allowed to make this in presentation. The court agreed, so the court considered the argument before it entered judgment. Wouldn't that take it out of the realm of waiver?
Well, when we typically talk about waiver, we talk about waiver on appeal, that something happened in the district court and then whether or not they can present the issue on appeal. But the district courts have also talked about using waiver to prevent a party from taking a position going forward. The case that we cited, Flume, it really kind of is both the Rule 32 and really this case is too. It's both the Rule 32 and the waiver issue. In Flume, it was a tax case. The government took the position that they had no objections, just like they did here. And then when the defendant objected to tax losses here, defendant objects and says, we think the tax loss is down here. Government comes to sentencing and says, oh, actually, we do have objections. We think the tax loss ought to be up here, right? And what the district court said there was they were not going to allow the government to take a particular position, in other words, assert a position, and then change that position later, and said it was waiver. And I think it's really important here that the court at least consider this as a waiver. The government in its brief says it was just confused. It was just uncertain about the guideline calculations and says there couldn't possibly have been a strategic reason that the government spent a year not testing these cereal bars, which I can't believe I'm up here talking about cereal bars, but okay. Sure, edibles.
Not just normal
cereal bars. Not just Rice Krispie treats.
Just in case you were confused.
Right.
marijuana edibles.
Yes,
and how
they are
the whole
edibles.
case is about how they should be weighed under the sentencing
Under the
guidelines.
sentencing guidelines,
That-
right? That they said they were confused. They had no prior knowledge of any of this kind of what could have
But
that they could have tested.
You're making more of an estoppel argument, not a waiver.
I'm
I-
having the same difficulty
Yeah.
that Judge Lee is having about
Okay.
thinking about this in waiver doctrine terms, because waiver doctrine is a limitation on appellate review and permits an appellate court to hear and review an issue that was not litigated in
Right.
the district court. This issue
Well-
was litigated. It was litigated late, and the defense was sandbagged because the
Yeah.
prosecution had said over and over again, we don't object to these drug weights on all the drugs that were found, and continued that up until
Right.
the day of the original sentencing hearing, and then said, oh, by the way, I learned yesterday, the prosecutor said, that
Right.
we're doing this wrong. We're weighing this wrong. We got to go get these edibles tested.
Right. Well,
and
whether
the judge
excuse me.
excused that untimeliness.
Without good cause.
And the question is whether there was good cause. So
And-
that's,
and
I'm
that's-
trying to fit it in the construct of the rules as opposed to waiver doctrine, which
Absolutely.
doesn't map well on.
Well,
this.
and it really is. If we move to the Rule 32, I first would caution the court that I think there could be a circuit split that you would create if you held, consistent with the district court, that Rule 32's deadline and Rule 32's good cause requirement essentially are overridden by a district court's general obligation or duty to calculate the sentencing guidelines. The Fifth Circuit and Chung, and they really collect the cases, but there are a lot of cases, both Court of Appeals cases and district court cases, that recognize that that Rule 32 has to mean something, right? And Rule 32 says that the court has to correctly calculate the guidelines. That's part of Rule 32. But what got missed here, I think, is the good cause requirement in Rule 32 is there's sort of a time requirement. And that is Rule 32 says the district court may take a late objection if good cause is shown. In other words, the government has the burden to establish that good cause before the district court exercises its discretion. Once the government shows good cause, then it says may.
So Jacob, what if the district court had said the following? I have to decide whether or not there's good cause to allow the government time of objection. On the one hand, I think the government's tardiness prejudiced the defendant. The government, on the other hand, I think the government only justification is that kind of changed its mind.
Mhm.
I also need to balance the interest of justice. And in balancing all those, I think in the interest of justice outweighs all of those other interests, because I think I would like to calculate the guideline range based upon the real facts on the ground.
Okay.
Would that be a sufficient use of district court's discretion?
I mean, by just using the term interest of justice, I would say no. And the reason that I say that, Judge, is for the good cause portion of the
So you're saying
rule.
that a judge could never consider the fact that the judge wanted to get the guidelines not only technically right, but actually correctly reflect the facts on the ground as part of a good cause analysis?
I think that the court can consider lots of this is not a very good answer, but lots of factors, right? But I think what the question, you have to pay attention to what the question is. The good cause question is, what happened here? Why are you late?
It sounds like you think good cause has to be grounded on the reason for the requested delay.
I think so, because what it says is the court has discretion. It says the court may take up a late objection, right? It may take up a late objection if good cause is shown. So first, you have to, the government has the burden. It has to show you a good faith, a good valid reason. if really what this meant was go to the merits, because that's sort of what that interest of justice thing is. Every time a party raises a late objection and says, I realized I did something wrong, I have a sentencing objection on the day of sentencing, I want you to hear it. It seems to me, if the interest of justice is you're going to get the guidelines correct, you'd have to either continue the sentence or leave the opposing party unprepared and take up the objection late.
Ms. Jacobs,
And-
if we agree with you, is this going to have an unintended consequence of hurting defendants? Because I can tell you, after 16 years on the district court, 99.9% of the time, when sentencing is scheduled and there's a request for a delay to change something, to add something, it's because defense counsel has just discovered something, defendant has said something new, that it's on the defendant that he's changed his mind about something. Is there going to be an unintended consequence?
Well, I hope not. And the reason that I say that, Judge, is because it's not just what's the reason, but I think that is a big part of the question that the court had. What does good cause mean? Why did we have this delay? But the courts, and we've cited these in the brief, both the district court and circuit court cases, it has to be something more than just simple neglect or a mistake, right? There has to be a good faith.
I'm not prepared. I'm not ready to go yet. I need more time.
Right. Okay. Well, I think that I don't know. I don't know what the circumstances are. I'm not ready.
I'm just
Okay.
not ready.
Well, the defendant has a Sixth Amendment right to effective assistance of counsel. So if the defendant's counsel comes in and says, I'm not ready, I think it's a real risk. It's prejudice to the defendant. It probably is prejudice to the government. So I'm not ready. It may not be. Again, every case is different, and that's really why this analysis has to be done case by case. But I know what the excuse was here, right? The excuse here was the night before the sentencing, somebody in the U.S. Attorney's Office decided that the way that this case had been handled for the last, I don't even know how long, 16, 17 months, was not the way they would have handled it, right? Up until that point, the Assistant United States Attorney had made a judgment call. He had made a judgment call not to have those edibles tested. Why? Well, he secured a plea saying, we're not going to use it. And I can come up with lots of other reasons. He wanted to avoid litigation, the very litigation, I'm not going to have time, but if we got to the ratio, there could have been litigation on that. He may have made a judgment that this was a fair and reasonable sentence. What happened was doubling of the guideline range. Okay. The defendant went to prison, presumably for at least 2 more years than he would have, at least, as a result of this change of position. It may be that because these cereal bars are legal, the government had made a decision not to have DEA resources in the lab used for this kind of thing. There's lots of reasons this could have happened. But the reason for the late objection was somebody in the U.S. Attorney's Office, and they say this at 4:35 the night before, decided they should have taken a different position. And it wasn't a legal position. Remember that when they come into that sentencing the next day, they still don't have a lab report. The briefing that happens after that hearing is, boy, the field test, it didn't even tell us if this stuff was marijuana, THC, hash oil. It tests positive, but it doesn't distinguish. So they didn't even know if there was a meritorious objection. What they knew was somebody in the U.S. Attorney's Office wanted this case handled differently.
How would you best state the rule that you hope will emanate from this case? The district judge, essentially, she didn't use the words, I find good cause because,
Right.
But she basically said, I have a duty, an independent duty to correctly calculate the guidelines range, and this is an important input into that guidelines range, and so I'm going to forgive the untimely objection and reopen this
Right.
matter.
Well,
and
yeah. The rule, I think, Judge, has to be consistent with the other cases, the other circuit courts around the country who have addressed this, is that the good cause requirement, the good cause showing, has to be made independent of or before we get to the potential merits of the objection. good cause, Rule 32 says the late objecting party must have a good reason. And the courts that have already looked at this in terms of a rule have said it is a balancing. I can't say that, you know, if it's so many days, then they get to do this, or if it's so many more days, or if it's the defendant, or if it's the government. I can't do that. But what I can do is I see all of the cases balancing factors like, is this a valid reason? Is it a good reason? Was there a good faith reason? And it's easy to come up with cases where the government or the defendant would have a good faith reason for bringing something late. Was this just neglect? Was there a strategic reason for what the late objecting party was doing beforehand that led to this problem? You know, is there prejudice to the other party? Was there prejudice to the judiciary? Does
Won't there always be prejudice to whichever side is not requested?
I would say no, Judge. There would have been no prejudice whatsoever to the government here if they had proceeded to sentencing, consistent with the position they had taken.
So, you're looking at prejudice if you go forward as opposed to if you continue it. I meant on the continuing. Isn't there, if good cause is found, or if a court continues the sentence at the request of one side or the other, isn't there often prejudice to the other side? Because they want to challenge something they haven't challenged.
Yes, but the easy example I think of this that would warrant a continuance, and again I recognize that I'm out of time, but I hope I can just answer your question. The easy example would be something like, and I think it's in one of the cases, 3 days before the sentencing, the government gets a witness calls and says the defendant has been trying to get me to lie for him, or obstruct something about the sentencing, or, you know, whatever. The defendant is currently engaged in some sort of obstructive conduct, let's say. Government comes in, day of the sentencing or the day before the sentencing, files something and says, we need a continuance. And the reason is we have a good faith reason, right? A valid reason. This wasn't raised consistent with the time limits in Rule 32, but instead, we need to sort this out, or we need to present this evidence because we now have a guideline. We want to get it right? We want to get it right, but we want to get it right outside these time limits because it's occurring outside the time limits. Just like I said, it could be that a defense attorney comes in and says, I haven't even reviewed the pre-sentence report, or, you know, I've spent 5 minutes with my client this morning reviewing it, and it's because I've been in trial. You know, he's got a Sixth Amendment right to effective assistance of counsel. I think that's a good reason. But this is not a good reason. This change of position with the U.S. Attorney's Office the night before the sentencing is not a good faith, valid, good cause reason for this continuation. And for that reason, and I apologize, I went way over my time.
Chief Judge,
sure.
Given me leave to ask one other question that has been bothering me. During the sentencing hearing, the judge goes through the guideline calculation. And as judges always do, hopefully, they said, okay, do both sides agree with my guideline calculation? And the judge specifically says, do both sides concur with the court's recitation of the applicable provision? Okay. And the government says, yes, Your Honor, and defense counsel says, yes, Your Honor. Why is that not forfeiture, or at least forfeiture, that waiver of the Rule 32 argument? Because of all of the objections that were raised up until that point, the court said, okay, well, these are the calculations, this is the guideline range. Does anyone have any objections? And both sides said, no, judge, they're fine. Isn't that the time for defendants? Doesn't defense counsel have the obligation to preserve whatever objections they have to the guideline calculation when the judge asks?
And with respect, when you say the guideline calculation, are you saying that they should have gone all the way back to the beginning guideline calculations, or are you talking about the 1 to 167 ratio guide, the 1 to 167? Yeah. That's why we argue plain error. I don't think it's waiver. I think it's forfeiture, like you said. And the reason is because this issue was never raised. I mean, the government tries in their brief to say, well, we've been talking about this all along, but the argument that we are making on the 1 to 167 never hit anybody's radar screen.
Are you?
And so with the plain error,
agreeing that it is forfeiture at that time?
it is forfeiture, but it is not waiver. And I'm making a very distinct, or I'm making that distinction. And that's the reason that we argue in the brief that it's reviewed for plain error.
Thank you.
And again, I appreciate all the extra time. Thank you.
Thank you. Mr. Simpson.
Good morning, Your Honors. May it please the court, I'm Scott Simpson on behalf of the United States. I'd like to start by pointing out that the court is facing quite a few issues here. As has already been pointed out, we didn't even reach the merits yet, which are also presented if we get past these preliminary issues. I wanted to point out that some of these issues here I would characterize as case management. The issue as to whether the court could consider the late objection from the government is case management. The issue of continuing the hearing to allow for testing of these THC edibles.
But
That's
case management still has to have good cause under Rule 32.
correct, Your Honor. And I'd like to point out, responding to an argument that defense counsel made, Rule 32 says that the court may, for good cause, allow a party to make a new objection at any time before sentence is imposed. I disagree that there's a two-step process there. The defense has said that there's a two-step process. Number one, they have to show good cause, and the district court determines whether there's good cause. And number two, then the district court exercises its discretion whether to allow that late objection. I disagree with that. May, for good cause. I think we want the district court to look at whether there is good cause, but all of that is one decision in the government's view. That is case management. That is discretion. And the reason I'm trying to distinguish these issues that we're looking at is that when we talk about case management, the standard of review there is abuse of discretion. Now, if the defense and the court want us to apply abuse of discretion to all of this, including the waiver / estoppel issues, I suppose that would be fine with the government, but really they are different. They are separate issues. Case management, we're applying abuse of discretion. So now if I could move to the waiver issues, and I appreciate Judge Lee's bringing up the waiver issue, the waiver by the defense. Whether we call the argument that the defense has made as to the government's action waiver or estoppel, I'm not sure that matters a lot. I think if the court were to rule, if the court were to reverse the district court in that regard, it would have the same effect, whether it's waiver or estoppel. The issue is the government did not, at the plea hearing, it's at the plea hearing when the government particularly said, we're not planning to rely on the THC edibles for conviction or sentencing. But the government made that statement true, but the government did not say, we're not going to rely on the 1 to 167 ratio. There was no reference to that. There was no discussion of that.
But didn't the government agree that the calculation of the drug quantity in the first PSR was correct?
Yes, Your Honor, that's correct.
And that used a 1-to-1. I mean, that didn't use the 1 to 167 ratio, right?
It used the 1-to-1 ratio, correct. But a couple of issues with that, Your Honor. And one of them we've already referred to, that is the district court's duty. I'll get to that in a moment. Our position is that that was not a knowing waiver on the part of the government. That is a knowing waiver in relation to the 1 to 167 ratio. The record reflects, and I want to emphasize this, defense has talked about it, the record reflects confusion and uncertainty on factual issues and legal issues, both on the part of the government and on the part of the defense. And those issues were the content of the THC edibles. You know, what really are these? They were labeled, they look like THC edibles, but it wasn't clear what actually do they contain. And perhaps more importantly, the ability to get any testing done. It wasn't the government delaying testing. It wasn't the government saying, we don't want to worry about testing these THC edibles. The government was trying to get that from the DEA, but it was having trouble doing that. Government counsel said at a pretrial conference in May 2021, quote, the lab, I think, had the inability to do certain testing as it relates to THC edibles and sent the entirety of the report back, close quote. So the problem was the ability to get the testing done. And the defense recognized that through all of the various, there were quite a few status conferences and so forth. All of the parties in the court recognized that there was a problem. There was a concern with being able to get that testing done at all. And the second problem with finding that the government waived here, or that the government was a stop, is that the court does have a duty to calculate the guidelines correctly. If the district court, as we know, if the district court does not calculate the guidelines correctly, the district court commits procedural error. And the district court in this case knew that and felt bound to, as I think one member of the panel.
How would it be procedural error if the government hadn't met its burden of proof of establishing the THC? If this had proceeded to sentencing in May or November of 2021, when it was originally scheduled, and there's nothing in the record about the cereal bars testing for THC, there would not have been an inaccurate guideline calculation based on what's in the record and the government's burden of proof.
I agree, Your Honor. If that had been the case, if everyone had proceeded with not being concerned about the THC edibles that were discovered in Mr. Slater's possession, if everything proceeded according to the earlier versions of the PSR, then correct. I don't think there would have been a procedural
Isn't the
error.
obligation to correctly calculate the guidelines based on what's in the record at the time?
But Your Honor, once the court decided to delay things, to allow for testing of the THC edibles, the government had information that this could be an issue. It became apparent that there was a hole in the record. And so the court was justified in delaying things to fill in that hole.
The concern I have with the role of the court's duty to correctly calculate the guidelines range is that there's no limiting principle, the extent to which that constitutes good cause. Essentially, any late guidelines objection is excusable on the basis of good cause if the good cause consists solely of the district court's obligation to correctly calculate the guidelines, because the court always has an obligation to correctly calculate the guidelines.
I can see the point, Your Honor, but I don't think that makes the obligation unlimited as to any kind of objection to the PSR. For example, there are all kinds of potential objections to a pre-sentence report that would not affect the guidelines. If there's an objection as to, the defense says my background is an error as to my background in the PSR. But there's an error, even an error describing the offense of conviction that doesn't affect the actual guidelines calculation. The argument that we're making would not require the district court to delay things.
So it's only late objections that will have an effect on the guidelines range.
Yes, Your Honor. Yeah, because and certainly it would depend on other factors here, on other circumstances. And here again, it's not just the court's duty to calculate the guidelines correctly. It's also this uncertainty and concern about the content of the THC edibles and the ability to test them. And our position is once the district court knew that issue was there, once the district court knew that there was that hole in the facts, in the underlying facts of the offense, then the court, we're not saying the court was bound, would have been required to delay things, but the court certainly was within its rights, was certainly not incorrect to delay things to clear up that issue in the record. If I could move on to the issue that Judge Lee brought up, which is the defense's action. And we believe the defense did waive did waive any objection to applying the 1:167 ratio. The final pre-sentence report, this is the pre-sentence report that was in effect when the sentencing hearing actually occurred. That final pre-sentence report included the 859 grams of THC edibles in Mr. Slater's offense, and it applied the 1:167 ratio in calculating his drug weight for base offense level of 24 on the drug count. And at the sentencing hearing, as Judge Lee mentioned, defense counsel, obviously we do want district courts to say, here are my guidelines calculations. Do you agree with that? And defense counsel agreed with the district court's recitation of the guidelines. And he acknowledged, I'll quote a little sentence from defense counsel at the sentencing hearing, because of the way THC is treated differently from marijuana, that's what's driving the guideline in this case, close quote. And it wasn't just that. It wasn't just lack of an objection, which sometimes we wonder, is that waiver or estoppel? We believe it was waiver because in addition to that, counsel then proceeded to argue for variance. He said, yes, I agree with that guidelines calculation. Then he proceeded to argue for variance, saying, and he specifically attacked the 1:167 ratio. He said the 1:167 ratio, choosing those exact numbers, defense counsel argued wasn't based on science. So he was accepting the application of that ratio, but he was saying, look, we ought to have a variance here because that ratio just isn't based on science, he argued. So that strategic agreement to the guidelines calculation, reflecting the 1:167 ratio, coupled with his argument for variance, does amount to a waiver of any objection to that ratio. To quote defense counsel's argument, that was an unequivocal waiver. That was a deliberate knowing waiver.
Strategic, though, as opposed to just arguing when the best he can to get a variance.
Well,
is there anything in the record that shows that he's consciously saying, okay, I'm going to let the guidelines stand. I'm not going to challenge the 1:167 guidelines, but instead I'm going to try to use that to get a variant and a better shot at that.
We don't know, Your Honor. I've never been defense counsel. We don't know for certain. But the fact that the 1:167 ratio earlier on was kind of an issue in the case, and then that at sentencing he said, okay, I'll accept that, but then arguing for variance, specifically attacking that the sentencing commission's choice of that exact ratio. I think it was very clear he's thinking, okay, I'm probably not going to succeed if I push back on the application of this ratio. So I'm going to try for variance by attacking the science behind the ratio, or he would argue the lack of science. That certainly seems strategic on the defense's part.
Where we say, if you use that similar reasoning, it seems that the government's decision to go with a 1:1 ratio was strategic in the beginning because the government wanted a very simple, easy conviction and didn't want to deal with the hassle of this objection with regard to the 1:167 ratio. And so the government made an affirmative decision to forego that argument, leave it on the side, and go forward with the plea.
Your Honor, we believe that the situations were very different. The defendant's waiver and the government's position were crucially different. The defense waived an objection to applying the 1:167 ratio in light of all the facts. The government statement was made with incomplete information, with an inability at the time to use the word.
It's a strategic decision because you don't have all the information, right? And so it's a cost-benefit analysis of all strategic decisions are. And the government decided, you know what, we're not going to wait for this, we're just going to go forward.
Your Honor, I can see that point. However, I think it's important to point out that here the government changed its position before the sentencing actually occurred, when the defense and the court had plenty of opportunity to change the thinking, to change the PSR, whereas with the defense's action was right at the end, and again, circumstances show that it was certainly strategic. If the court would look at all the, and I agree it would be a lot of reading, all of the status conferences, the transcripts and so forth, there was a lot of discussion about this inability to get testing of the edibles, a lot of discussion about how it was going to affect things. Finally, if I could, just a minute on the merits. We haven't talked about that yet. If the court gets past all these preliminary issues, the merits would have to be faced in. And the case law and the guidelines are clear that a defendant's sentence for a drug offense, except as stated in the guidelines for certain drugs, should reflect the entire weight of any mixture or substance containing a detectable amount of the controlled substance. And the Supreme Court, although Chapman was related to statutory language, it was very similar language. I see that my time has expired. If I could just
finish your thought.
Thank you, Your Honor. Although Chapman related to statutory language, it was pretty much the same language, very similar language. And under Chapman, it's clear that the guidelines should be applied exactly as they're written in that respect. The penalty for a drug distribution crime should include the weight of any carrier medium, this is quoting from Chapman, any carrier medium that is ingested with the drug and facilitates its distribution. So just like the LSD blotter paper in Chapman, the THC, the edible portions, I believe these are cereal bars, that edible material in these THC bars involved here is a carrier medium that facilitated the distribution of the THC edibles. The distributors, the manufacturers choose how they're going to distribute. And here they chose to distribute using those edible bars. And the sentence correctly reflects that fact. So we would urge the court to affirm. Thank you.
Thank you. Ms. Jacobs, your time had expired, but you can have a minute additional time if you have anything to say in rebuttal to Mr. Simpson's argument.
I always have something to say, Judge. I'm sorry. The reason you know this wasn't strategic is nobody ever talked about the cost denial of the en banc decision. If this had been a strategic decision in any way, that to avoid this 1 to 167 issue, or there would have been some discussion about that, and there was not, and there never was throughout the case. That cost decision is 2016. If this is something that the defendant decided to give away at some point in the case, it would have come up. This is a plain error standard. This is not waiver on the ratio issue. Couple last things. I respectfully, I disagree with the government that Rule 32, when it says may for good cause shown entertain late objections, that may also has to mean something, right? That's the discretion. If good cause is shown, then the district court gets to decide. It can entertain one or it doesn't have to, but good cause has to be shown first. And with that, I would ask that you vacate the sentence and remand for resentencing. Thank you.
Right. Thank you very much. Our thanks to both counsel. The case is taken under advisement, and we will take a brief recess so that we can bring some other students in. We'll be back in a few minutes for the remaining 3 cases this morning.
I mean, I guess the public. Yeah, you know,
on already.
Test 1 2, test 1 2.
Hopefully, I've been hearing complaints about my like popping minutes. I know it's just right. I know it's right before, so I'm like, let me just get rid of it. Swap this up. Briefs, record statutes. I'm not sure. Should be okay. No, we're trying to. I guess you just, yeah. Is what it is. It's fine. Yeah, we didn't. They provided those microphones, so close enough that the judges should be able to hear me anyway, right? Stand here. That's about right.
This honorable court is now in session. Please be seated and come to order.
All right, our fourth case for argument this morning is Bernardo de la Cruz versus Garland. Mr. Rubenstein.
Thank you, Your Honor. May it please the court. I'm here this morning, as you say, on behalf of petitioner David Bernardo de la Cruz. Mr. Bernardo has lived in this country for approximately 2 decades. During that time, is that better, Your Honor? During that time, he has been, as the immigration judge found, and as the government does not contest, a person of good moral character. The agency proceedings through which the government has nonetheless attempted to remove Mr. Bernardo from this country were fundamentally flawed in several respects, and I'd like to begin with the Appointments Clause challenge. So, as we explained in our reply brief, that argument proceeds in 3 steps, only the last of which the government actually contests. The first step is, of course, that inferior officers may be appointed only by the president, the courts of law, or the head of a department. That's right there in the Constitution. No dispute as to that. Second step in the argument is that temporary board members, like Mr. Gonzalez in this case, qualify as inferior officers for purposes of the Appointments Clause. The court doesn't have to address that on the merits either because the government has forfeited any argument to the contrary. That brings us then to the crux of the case. Was Mr. Gonzalez validly appointed by the Attorney General? And the government argues that he was because of the appointment papers submitted with their brief, under which Acting Attorney General Rosen purported to appoint Mr. Gonzalez as a temporary board member. The problem for the government is that in order to validly appoint for purposes of the Appointments Clause, there has to be statutory or regulatory authority to carry out the appointment, and there is no such authority in this case. Now, the government has pointed to a couple of different provisions of the regulations implementing the Immigration and Nationality Act, under which it says that the Attorney General had such authority. Neither of those works. The first is 8 CFR section 1003.1A1 that deals with ordinary board members. The other is A4 dealing with temporary board members. I'd like to just quickly talk about A1. Here, the government made no argument under A1 in its opening brief. So again, that's forfeited. Even if it weren't, the decision of the Fifth Circuit in its unpublished Mboba opinion is respectfully incorrect. That decision failed to recognize the distinctions between temporary board members under A4 and ordinary board members under A1. Specifically,
isn't it clear here that the acting Attorney General appointed the temporary board member in 2021 based on the submission by the government?
So the Acting Attorney General, Mr. Rosen, did purport to appoint Mr. Gonzalez in 2021 as per that appendix. However, he lacked regulatory authority to do so. And under the Supreme Court's decision in Muat, if there is no statutory or regulatory authority for the head of the department to act, that doesn't count for purposes of the Appointments Clause. So it's still an Appointments Clause issue. And the reason that there's no...
There's a difference though in the regulation. I mean, you rely upon the regulation and the difference between A1 and A4, right? Temporary board member.
Correct.
A4 says the director may, in the discretion, designate immigration judges, whereas A1 states that the board member shall be appointed by the Attorney General. So doesn't that lead to the conclusion that appointing someone and designating someone are two different things? And so here the government argues that designate is recommend, right, and appoint is simply appoint.
So I don't think that could be squared with the language of A4, Your Honor, because while it does say designate rather than appoint, the object of the designation is, I'm quoting now, to act as a temporary board member. It's not a designation for review by the Attorney General. It's not a designation for consideration as to whether this is a good person to appoint or not.
But if the regulation was intending for designation to be the same as appoint, wouldn't they just use the same word, appoint? I mean, given the fact that two different typical statutory construction, two different words mean two different things in the same statute, right?
Well, yes, Your Honor, but there's actually strong exclusio inference then that the Attorney General doesn't have any role in A4. As you note, under A1, the Attorney General is specifically given the authority to appoint. That would be unnecessary if, just based on the existence of regulation, he had such authority anyway. On the government's reading, the Attorney General has the authority to appoint under A4 without any explicit conferral of that authority. That doesn't make sense in light of A1, where just such an explicit conferral of authority is given. And then there's a second exclusio inference to be drawn in A4 from the specific reference to two other officials, the EOIR director and the Deputy Attorney General, whereas the Attorney General is entirely absent from that provision. So I think when you combine those two exclusio inferences and you look to the discretion, which is another factor in under A4, the discretion it gives the EOIR director to designate shows that it is his personal opinion, his personal judgment who the right person to name in Lucia's language is. But Your Honors, even if you didn't agree with that, even if you thought that the Attorney General had a valid role to play under A4, if you accepted the government's reading of the regulation in full, that wouldn't cure the Appointments Clause issue here. They would simply run into a different Appointments Clause issue, and that's the one flagged by Myers in the Supreme Court almost a century ago. And what Myers says is that one who lacks the constitutional authority to appoint, like Congress in Myers or like the EOIR director here, also cannot impose restrictions that amount to designation. Myers says you can't designate. That's the very word it uses to describe what one without authority cannot do. It's also the word that A4 uses to describe what the EOIR director is actually doing. So under Myers, there's an appointments clause problem whether or not the government's reading of the regulation is correct. The executive branch itself has recognized that. All the way back in 1871, Attorney General Ackerman recognized that a statutory scheme under which the Civil Service Commission would tell the heads of departments who to appoint would be invalid because it would make the Civil Service Commission, which, like Congress and Myers and like the EOIR director here, lacks constitutional authority to appoint, they would nonetheless effectively be the appointing entity. That can't be. More recently, OLC has recognized in the context of the statute governing appointment of the U.S. Trade Representative that a restriction placed on one with appointing authority that limits their scope of discretion such that many of those best qualified are no longer eligible cannot stand under the appointments clause. That's the executive branch's own theory. Here, A4, even on the government's reading, goes much farther than that. It precludes the attorney general from appointing not only many of those most qualified to serve as temporary board members, but every last person who is best qualified except for the one that the EOIR director happens to designate. And in some cases, the deputy attorney general happens to approve. As a result, it simply can't be the case that the attorney general has been restricted to a role that's more akin to the Senate's role in principal officers of merely evaluating candidates that have been named in Lucia's language or designated in.
That line of cases, those are separation of powers cases. We don't have that problem here. These are executive branch regulations promulgated by the attorney general himself, who has plenary authority to establish the procedures by which these removal proceedings are held. So the attorney general can change the regulations anytime he wants to.
That's correct, Your Honor. The attorney general can change the regulations anytime he or she wants to. The attorney general could, in all likelihood, promulgate a regulation saying the attorney general shall appoint temporary board members, but he hasn't done so here. And if you look at the appointment papers that the government submitted, he purports to appoint Mr. Gonzalez, quote, as described in 8 CFR section 1003.1A4. And as 1003.1A4 currently reads, that makes the designation of the EOIR director an absolute prerequisite to his authority to appoint. And the attorney general, while he may be able to change the regulations, is bound by the regulations as they currently exist. That's the Supreme Court's decision in Accardi, where the Board of Immigration Appeals was considering a cancellation decision, and the attorney general essentially put out a list of people who would not be eligible for cancellation. Now, even though the attorney general was going to have ultimate review authority over the decision, the regulations gave the Board of Immigration Appeals discretion to assess whether the applicant would be eligible for that relief in the first instance. When the attorney general overrode that discretion with his list of people who were not allowed, that violated the regulations as they exist, and that was why the decision had to be vacated and sent back. Similarly here, although the attorney general might have promulgated a regulation allowing him to do what he purported to do, that regulation is not on the books. There's, as a result, an appointments clause problem. And as a result, we would ask that you vacate and remand on that basis.
The attorney general is the head of a department.
The attorney general is the head of the department, yes.
Has plenary authority to make appointments.
The attorney general under MUAT only has plenary authority to make appointments as authorized by a statute or regulation. And the
statute authorizes him to appoint anybody and to appoint the officers within the system that he himself controls and sets the procedures for. So again, there's no separation of powers problem here. The head of the department is in complete control of this process.
Well, the statute authorizes him to promulgate regulations governing the procedures. And he is then bound under Accardi by the regulations he has promulgated. But, Your Honor, even if you don't think that there's an appointments clause problem, there's still a failure to comply with the regulations as they exist. And the failure to comply with the regulations as they exist is itself a basis to vacate and remand, as the government's own case, Medina Carry-On, makes clear.
But that's a separate argument from the constitutional argument.
It's a separate but related argument. That's correct, Your Honor. But I think they get you to the same place. Either one results in a requirement to vacate and remand for further consideration. I see I'm almost in time.
Unclear. We'll get that cleared up. Not sure where that's coming from. 2 weeks ago, we had Siri zooming in when one of the participants in the hearing was on Zoom. These things happen sometimes. Go ahead. It's quiet now. You can wrap up your primary argument.
Thank you, Your Honor. So just a quick minute on the merits of the case. Even if you don't agree with the appointments clause in the ultra vires argument, the immigration judge erred in 2 fundamental legal respects. The first is that he failed to follow binding board precedent when he failed to find where Mr. Bernardo's children would live, but more importantly, carry out the analysis required under cases like Cabrera-Alvarez to assess assess the emotional and assess the financial harm that would flow from that.
The issue of where the children were going to live was never disputed. The record below was clear that they were going to stay in the U.S. and not go to Mexico.
That's correct, Your Honor. But if you look at the entirety of the immigration judge's decision, particularly the analysis section, there's no acknowledgement of where the children will go. The only 2 cases that he cites are cases in which the children of the removed non-citizen would accompany them overseas. He doesn't carry out the analysis of how will
Given that there's no dispute, why wouldn't it be harmless in essence?
Well, I think that it's not just the lack of the magic words, I hereby find the children are going to remain in the country. It's the failure to conduct the analysis that necessitates under cases like In re Monreal and Cabrera-Alvarez. And that I see that I'm about to enter my rebuttal time, reserve the balance of my time. Thank you.
That's fine. Thank you. Ms. Dunn.
May it please the court, Lindsay Dunn on behalf of the respondent, Merrick Garland. Unfortunately, in this case, Mr. Bernardo de la Cruz did not meet his statutory burden of establishing eligibility for relief before the agency. But that doesn't translate necessarily into agency error. And here, the agency did not violate the Constitution or otherwise commit legal error in denying Mr. Bernardo de la Cruz's claim. And the arguments to the contrary are insufficiently tethered to either the facts of this case or the law as it's currently applied in this circuit and the various sister circuits. I'll start with the appointments clause issue because that's at the heart of this case. The government does not contest that the temporary board members at issue, and specifically Mr. Gonzalez, is an inferior officer requiring appointment by head of the department. But the government does note that the Mboba case came out after the government filed its brief. The government did file a 28J about that case, and petitioner had the opportunity to rely on that case in its reply brief. The analysis in Mboba does go further than the government. So the government, in its response brief, distinguished between designation and appointment as 2 separate things that could happen within the same statutory, or pardon me, within the same regulatory scheme. And Mboba goes farther at looking at that, pardon me, provision in A and saying A1 says that the Attorney General has the authority to appoint board members. A4, which is within the same section, refers to temporary board members and specifically their designation by the EOR director. And with respect to those in the situation like Mr. Gonzalez, who's at issue here, the temporary board member who issued this decision, the approval of the Deputy Attorney General. But this is all within the same section of the same regulation, A1 and A4, that these provisions can be read in concert with each other. The temporary board members are indeed board members, and so that provision at A1 covers their appointment. And that also makes sense when one looks at what actually happens. The government filed these supplemental papers showing the appointment happened by the acting attorney general at the time.
And it was after a designation by the director for approval, correct?
Yes. And I want to take a moment to discuss the issue that was brought up with respect to the role of the deputy attorney general, because we can't just look at these provisions in a vacuum. So the Deputy Attorney General under 28 CFR 0.15 has the power authorized to execute the power of the Attorney General, quote, unless such power or authority is required by law to be exercised by the Attorney General personally. So when we read those sections in concert and also consider that his role here is approval, not appointment, and that it's within the same section, all of this works in concert, particularly when you consider that under 28 CFR 0.15, much of the Deputy Attorney General's responsibility does relate to appointment and employment matters. But here, if he cannot by law actually do the appointment, then these provisions work together and make sense that it is actually under A1 that the board members have to be appointed. Also, I asked the court to look at the provision, the regulation as a whole, because there are instances where the regulation does make a distinction between board members generally, and that would include the temporary board members, and specifically permanent board members. And all of those provisions relate to voting in en banc. And I'll point the court specifically to 8 CFR 1003.1A5. That relates to the en banc process. So the temporary board members come, they have the full authority of board members, but they don't participate in that process. And then the other reference to permanent board members is at 8 CFR section 1.003.1G3. That again relates to designation of precedents. This all, when one reads the regulation as a whole, makes sense. So there are board members, and that's part of the 23 who are critical for the voting in the en banc process. And every provision related to specifically voting also specifies that that's those permanent board members. Then there's only one provision that specifies different conditions for temporary board members, and that is just at A4, talking about how the different process by which they are chosen. And even the wording makes sense because as was pointed out, this is a different situation than what's being discussed in Myers, where you have a separation of powers issue. EOR is a creation of regulation. Congress gave the Attorney General authority to create EOR by regulation. And under regulation, the Attorney General not only creates EOR, but also creates the provision creating the director's role. The Attorney General actually appoints the director. So, So all of this is within the purview of the Attorney General. He's creating the regulations. He's also here creating the terms of the pool. And specifically with respect to Mr. Gonzalez, it's an attorney who's worked at EOR for over 10 years, those are the qualifications, who then is chosen by the EOR director or identified by him. This all makes perfect sense with the approval of the Deputy Attorney General, and then finally with the actual appointment by the Attorney General. Again, when read as a whole, all of these provisions make sense together. And it is quite different from the cases that counsel for petitioner raised in his reply brief upon seeing the supplemental appendix, because again, all of those relate to separation of powers, and one can't treat the EOR director as though he is the same as Congress. It's just not the same issue. He is under the purview of the head of the department, the Attorney General. I also do want to clarify another point that came up in the reply brief with respect to, in this case, the alleged lack of involvement by the Deputy Attorney General. So here, Acting Attorney General Jeffrey Rosen appointed Gabriel Gonzalez, the temporary board member who heard this case. But at the time of the appointment, the Acting Attorney General was actually the Deputy Attorney General. There was no Attorney General, and then so under 28 USC Section 508, in the case of a vacancy in the office of the Attorney General or of his absence or disability, the Deputy Attorney General may exercise all of the duties of that office. And for the purposes of Section 3345 of Title V, the Deputy Attorney General is the first assistant to the Attorney General. That other provision that is referred to has to do with the acting officer provision, which again describes the first assistant, who in this case is the Deputy Attorney General, performing the functions and duties of the office temporarily in an acting capacity. So it's not that the Deputy Attorney General was not involved in this specific appointment. He was also the Acting Attorney General. And
he's in a dual role.
Yes, he's in a dual role. So he does actually do the appointment as the Acting Attorney General. But at the time, that was one of his duties in his role as a deputy attorney general, and the power goes straight through to the executive office because as the deputy attorney general, he was Senate nominated and confirmed. I mean, he was presidentially nominated and confirmed. So all of this checks out when read all together. It's just putting together the pieces that might be a little bit tricky. And I do also want to note, with respect to the separate ultra-virus claim that was raised in the opening brief. So the argument was either there's an appointments clause issue. I don't think that exists here. In the alternative, that there's an ultra-virus issue, I don't think that exists as well, because when the regulation is reviewed in its entirety and also reviewed in concert with those provisions regarding the role of the deputy attorney general, all of this checks out completely. But then the last argument being, because it's a constitutional issue, one doesn't have to show prejudice. And that argument was made in the opening brief and then also in the reply brief, and petitioner relies on Bridges. But I want to note, even if the court did view this as the attorney general violating his own regulations, there's still an exception to that, or at least there has to be a showing of prejudice, especially in the absence of a constitutional violation. And I specifically point the court to Ward v. Holder at 632 F. 3rd 395. There, the case involved a question as to whether or not the agency was violating its own regulations in terms of a petitioner looking at his final order of removal and saying, why is there only one board member who signed this? Under the regulations, I'm interpreting this order as being complicated enough to require a panel of 3. And the court requiring not only that the regulation first be found to serve a purpose to benefit the non-citizen, but then also the second part of that analysis requiring that the prejudice interests of the non-citizen protected by the regulation also be demonstrated. And when this circuit developed that test, first in Martinez-Camargo, that's at 282 F. 3rd 487, the court did consider what petitioner raises in Bridges in terms of, are these rights so fundamental that we can presume a constitutional violation? And the court determined, no, we need to balance that out. Specifically, the court stated in Ward that the analysis adopted in Martinez-Camargo endeavors to strike a balance between recognizing the need for administrative agencies to follow their own rules and acknowledging the practical reality that not every agency violation impacts a non-citizen substantive rights. And here, there simply was no allegation of prejudice. So again, even if the court determined that somehow the attorney general was violating his own regulations, which under the regulatory scheme, he was not, there was no allegation, much less showing of prejudice. So it just, the arguments simply do not work. I have been speaking for a very long time. Does the court have any questions?
Do you have anything to say on the merits argument about how the immigration judge and the board, acting through temporary board member Gonzalez, handled the merits argument against cancellation of removal here? In other words, the hardship to the children.
Mm-hmm. So I do want to specify that this particular case, although the Seventh Circuit does consider as a mixed question of facts and law the hardship analysis, that's not raised here. The only thing raised was did the agency actually err in the process of its decision? And the answer to that question is no. I mean, the first part of that challenge involved whether or not the immigration judge was required to specify a completely uncontested fact that occurred twice in the documentary evidence, that occurred twice in testimony, that was never disputed by either party. And the answer is no. There's no case law that specifies that the agency has to lay out findings of fact in a particular way, especially where a fact is entirely uncontested. And particularly in the context of a cancellation of removal case. Petitioner does not point to it. And specifically in one of the cases cited by a petitioner in regarding SH, and that's at 23 INN 462, there is still a recognition that immigration judges have latitude as to how they lay these decisions out. And I do ask the court to think about what petitioner is asking for here, where a fact is completely uncontested, where it comes up multiple times in the record, and again, where it's not even being contested here. We know the children will remain with their mother.
What do you make of the typographical error in the IJ decision? That is, the parties give kind of competing views of how they think it should be interpreted.
So it is acknowledged as a typographical error. And when read in context, the entire paragraph, the special needs analysis checks out. There's a typographical error, but the immigration judge still acknowledges that Wendy has trouble reading, but ultimately there's no special needs, and the specific language that is given in the parenthetical is that those needs don't rise to the level of requiring an individualized education plan. And I will read that, such as through an individualized education plan. So that's really the basis, that there's no special needs in that regard. This argument was raised below, and the board also looked at it, and in its affirmation of the immigration judge's opinion, relied on that fact, acknowledged the literacy classes that both girls were taking after school, but ultimately the fact on which this relies has to do with there's no IEP or individualized education plan. That's consistent. And the cases that petitioner relied on in his opening brief and also in the reply brief have to do with either ignoring a swath of evidence. So in Martinez-Baez, it's the exact opposite thing happens. There's an individualized education plan. There's also testimony from an expert that's ignored. This didn't happen here. It just wasn't sufficient to make to rise to the level of hardship. The other argument being that the decisions weren't sufficiently reasoned. They were. We know the reason on which this was decided. There's no IEP, and that remains uncontested. I have reached the end of my time. Thank you, Your Honors. Thank you.
Mr. Rubenstein.
Thank you, Your Honor. Just a few quick points. I'd like to start with Mboba. And at the outset, I don't think that the issuance of an unpublished decision by the Fifth Circuit excuses the government's forfeiture. But even if you look to the Mboba argument, it's flawed on its merits. Under A1, there are 23 board members allowed. That's the maximum number that can be appointed under A1. And if you look at the appointment papers themselves, the recommendation memo from the EOIR director specifies that all 23 of those spots were filled at the time that Mr. Gonzalez was appointed. So he can't be an appointee under A1. And if you look at the regulation as a whole, as both sides encourage you to do, that supports the distinction between the two and supports that A1 can't provide the support. The regulation doesn't say, A, the Attorney General shall appoint sub-1 board members, sub-4 temporary board members. The Attorney General shall appoint language is all within A1. A4, the parallel provision, not the underneath provision, does not have similar language. Second, as to the Deputy Attorney General, my understanding was that when the Deputy Attorney General is an acting Attorney General, there is also an acting Deputy Attorney General who should have provided approval. To the degree that did not happen here, we think that that is a separate...
What's that based on?
I'm sorry?
What is your argument that there is an acting Attorney General? When there's an acting Attorney General, there's also an acting Deputy Attorney General.
So I believe this... I don't have that statute cite for you. I had thought that was how it worked. I may be incorrect about that. But in any event, that doesn't cure the problem here. Appointments clause authority can't be delegated. I acknowledge that Myers is a Congress case and the other things are Congress as well. But the whole point of the appointments clause is to vest the appointment authority in the politically accountable people.
I thought we had clarified that this isn't an appointments clause constitutional argument. It's a ultra vires argument.
We're making
two separate things.
We're making both, Your Honor.
I know you're making both, but this issue of compliance with the regulation is just an ultra vires argument, not a constitutional appointments clause argument.
It goes to ultra virus, but it also goes to the constitutional argument because of Muat, which says if you don't have the regulatory authority. So a violation of the regulation is an ultra virus argument. If there's no authority in the regulation to begin with, then that's the appointments clause argument.
But if Mr. Rosen was wearing two hats, acting attorney general and deputy attorney general,
yes,
he was a busy guy, but he was authorized to do what he did here.
That's the deputy attorney general point is only an ultra virus point. That's correct, Your Honor. As to the cases requiring prejudice, even if you thought it was ultra virus, Accardi shows there's no prejudice requirement. There plainly was no prejudice in Accardi, where the attorney general had ultimate review authority over the decision at issue and had already telegraphed how the way he was going to exercise it. Nonetheless, it still had to go back. I see I'm just about out of time. We are happy to submit in our briefs on the voluntary departure issue. Of course, I'm happy to answer any questions the court might have.
All right, thank you very much. Our thanks to all counsel. The case is taken under advisement. And we'll move to our fifth case this morning. United States versus Brian Cook. Mr. Frederick.
May it please the court. I'm Terry Frederick. I'm from the Federal Public Defender's Office in the Central District of Illinois, appearing on behalf of the appellant, Brian Cook. Your Honors, brandishing a weapon as a guideline enhancement was meant to exist. And like its more serious counterpart, other use of a dangerous weapon, it was meant to encompass a range of conduct. Now, the upper limit of other use of a dangerous weapon has always been very well defined. It's discharge of a weapon. Similarly, the lower limit of brandishing has also always been very well defined. It is essentially gesturing at a lump in your clothing and suggesting that there's a weapon secreted there. Somewhere in the middle, those two comprise a spectrum, and somewhere in the middle is a line whereby on one side of that line it's brandishing, and on the other side of the line it is other use of a weapon. That line has never been very well defined by this court, or so far as I can tell, any other court in the country. This is the perfect case to draw that line definitively, because the threat of harm visited upon the tellers in this case by Brian Cook wasn't personalized in any sense of the word. You are being robbed. Those are the only four words Mr. Cook was quoted as saying when he entered the Citizens National Bank in Roseville. No one said he had an elevated tone of voice. No one said he was forceful. No one said he was screaming. I'd submit that he was calm, that he said those words almost robotically. From 8 to 10 feet away, he pointed a BB gun, pistol, at one teller and then the other for seconds each, directed them to fill his bag with money, and he made off after 1 to 2 minutes.
So when a person points a gun at you, and you don't know whether it's a BB gun or not, right? How is that threat not personalized? You're the only one in the room, or the only one in the area. We're about 10 to 12 feet apart, right?
Sure.
If someone's standing there would point their gun at me, I would think that threat is very personal.
Specific leveling of a firearm has been adopted as, I guess, the criteria as a criteria for other use of a firearm in the 9th and 1st Circuits. I believe the government probably advocates for this circuit to adopt that standard, but this circuit rejected that standard in, I believe, the Kruger case. And it adopted a more holistic standard, which I think is more appropriate. And that includes conduct such as pointing that gun directly at someone's head. pointing it at a specific body part, accompanying the pointing of the weapon with a threat, ordering someone to the ground. These are all prodding someone with a firearm or a facsimile firearm. Either of those things, any of those things, all of those things have been held to comprise other conduct.
They're sufficient, but not necessary.
This court has repeatedly held that there's no definitive, that any combination of things can be otherwise used, but brandishing includes display of a firearm to intimidate someone. And from 8 to 10 feet away, this is probably near the upper limit of the brandishing spectrum there, but it should encompass a range. And because there was nothing personalized about this case, this is a perfect case to draw that upper line of the brandishing
Why wouldn't
range.
the statement from your client, you are being robbed, at the same time he's pointing the gun, why doesn't that cross the line and amount to a specific threat of harm?
I would analogize it to another case where it was held to be other use, where the person, the robber, there was other conduct as well, but said, I don't want to hurt you. That was meant, that carried an implicit threat of harm, that if you don't comply, I'm going to hurt you. You are being robbed. It's such a mechanical statement. It is such a non-emotionally charged statement.
But when he isn't just saying that, he's pointing the gun at them at the same time.
For mere seconds, it was a BB gun from 8 to 10 feet away, and for mere seconds, he did.
You're the teller.
Not saying that tellers wouldn't feel, but we base our enhancements and our criminal sentences, for that matter, on the conduct and the intent of the defendant in criminal cases in generally in the United States. More than we don't take eggshell plaintiffs in the criminal law and aggravate sentences on that behalf. And that takes me to one of the procedural errors that the district court applied in this case, which is the district court invented a guideline enhancement out of whole cloth, which is a small town bank enhancement. Clearly one of the factors that she relied heavily upon in aggravating and nearly doubling Mr. Cook's sentence was the fact that he had committed this offense in a small town. That is very problematic, Your Honors, because if you uphold that basis as a justification for aggravating a sentence, what you're saying to tellers who work in large towns and big cities, we're not going to protect you as much as people in a rural area. You are assuming
that in order to be aggravating a factor actually we've never said that.
No, it's clear that judges may depart from the guidelines and have a philosophy at variance with policies within the guidelines, of course. But when they depart drastically in their sentence from the guideline range, as the district court did in this case, that warrants searching review. And there are, other than the guideline error, there's the invented guideline, which is the small town bank enhancement.
Well, that wasn't a guidelines error. There wasn't a guidelines enhancement. That was a factor that the judge used as an aggravating consideration in deciding to issue an above guidelines sentence. It had no effect on the guidelines range.
I wasn't asserting that it was an actual guidelines enhancement, Your Honor. I was saying that effectively it became a guidelines enhancement because the district court in this case essentially disregarded Mr. Cook's argument that 4 of his criminal history points were marginal at best. 2 of them don't count as of today, as a matter of fact. We have a new manual that came out today, and the 2 status points that he was.
She didn't disregard it. She just didn't put the weight on it that you did.
Well, if she offset his criminal history by any amount for it, then it's amazing how far over she went over in the guideline table, because she jumped from category 4 to category 6 as it was, and then down an offense level as well in order to reach the guideline range that she imposed of 12 years in this case. As we stand here today, Brian Cook would be category 3 because he's had a Missouri pot conviction expunged, and he's also wouldn't have those 2 status points. So she sentenced him as though he was category 6, and then she added an offense level beyond the ones that were already calculated in the guideline range. Your Honors, I will reserve the rest of my time for rebuttal.
That's fine. Thank you. Mr. Simpson, welcome back.
Thank you, Your Honors. May it please the court, I'm Scott Simpson on behalf of the United States. Your Honors, the guideline enhancement in this case was thoroughly justified, and the overall sentence was substantively reasonable and well explained. First, on the enhancement, the defendant, of course, can get the lower brandishing enhancement just by giving the tellers a peek at his weapon, saying, "Look, I've got a gun," or just by saying, "I have a gun." You don't even have to show your gun. The defendant doesn't even have to show his weapon to the victim to get that brandishing enhancement. But Mr. Cook did a whole lot more than that in this case, and actually take issue with some of the factual statements that defense counsel has made here. All we need to do is look at the three pictures in the government's brief here. In all three pictures, Mr. Cook was leveling his weapon at shoulder height with a stiff arm and pointing it at each of the employees. He pointed the weapon at the first teller and said, "You are being robbed," and he kept pointing his weapon directly at her with that same stiff-armed position as he walked toward her. You can see in the picture on page 6 of our brief, he's pointing the weapon toward the teller's head very clearly. She's standing behind a counter, looks like a fairly high counter as you sometimes see in a bank. And apparently all that Mr. Cook could see of this first teller was her head and upper body.
Is just pointing the gun sufficient for the enhancement, or does it have to be something else with it?
Your Honor, certainly in this case, otherwise using is justified. It's hard to tell.
Based on the just pointing at the gun or something else?
Your Honor, if you look only at the guidelines say, again, brandishing can be just saying, "I have a gun." We're not here arguing this, but one could argue that pointing, in addition to having a gun, could support otherwise using. But here we have a whole lot more than that. If you look at the video as well, in addition to those three pictures, there's a video among the sentencing exhibits. If you look at the video, you can see that Mr. Cook comes in, he's holding that weapon up with that stiff arm posture, pointing it at that first teller. And you can see in the video, he's walking toward that teller while he's continuing to hold out his gun with that same stiff arm posture as he walks toward the teller until the weapon, you can't see the teller herself in the video, but based on Mr. Cook's approach, nearness to the counter in front of the teller, looks like that gun got to maybe about 3 or 4 feet from the teller, again, from the teller's head. Then he pointed the weapon at his weapon at the other teller and said, "Stay where you are," or words to that effect. There's at least an implied threat in those words. "Stay where you are," and I'm pointing a gun at you. You're basically implying, "Stay where you are or I'll shoot you." So the 4-level enhancement here was clearly justified. And even if it weren't actually justified, the district court said that those circumstances would justify the same sentence under the section 3553A factors. So now if I could move to the overall reasonableness of the sentence and the court's explanation. There were several aggravating factors that the court talked about, several aggravating factors in Mr. Cook's offense, and several aggravating factors in his criminal history that the district court also referred to. He pointed his weapon directly at 2 tellers, as we've talked about. He studied the bank and bank robberies in general in some detail very carefully. He apparently chose this bank because of it being in a very small town. That's very striking. He chose this bank for some reason. In the 2020 census, Roseville, Illinois, had a population of only about 1,000 people, very tiny place. So he obviously targeted that bank for some reason. And as the district court said, Mr. Cook probably figured that there would be less security at a very small town bank like that. Also, in relation to the scope of the offense, I'm not sure we referred to this before, he came away with a large amount of cash, almost $200,000. That's a huge haul, compared to a lot of bank robberies these days. Mr. Cook also tries to downplay his criminal history, but let's look at it. According to the PSR, if you look particularly at paragraphs 36 through 44 of the PSR, looks like he was in custody for burglary, theft, stealing, forgery, and similar crimes pretty much continuously. Some periods of being out on parole, but pretty much continuously from 1982 to 2007. So that
the court say that he's been in and out of jail since the age of 18, I think.
She said words to that effect, in and out of prison his entire life with theft offenses, exactly, something along those lines. The forgery offense that I just mentioned involved a government check for $19,000, pretty large government check. Mr. Cook committed several of those crimes while he was on parole or probation, and his parole or probation was revoked a number of times. He had at least 2 fugitive warrants against him at various times, and he had at least one actual conviction for escape. Mr. Cook's last term of parole on all those crimes, and I'm talking about the ones where he was in prison pretty much continuously from 82 to 2007. His last term of parole on those crimes ended in 2010, so it would be about 11 years before this bank robbery. Then in 2010, he was convicted of another crime of burglary and stealing, and unfortunately, he got a 7-year prison sentence, but it was all of that was suspended, pretty much a slap on the wrist. And he completed probation in that case in 2014. So what's that? About 7 years before this bank robbery. And in 2020, he committed 2 more crimes of stealing, only got fines in those 2 cases. And then in 2021, he commits this bank robbery. In light of all that history, I think the district court was certainly justified in saying, she actually said it twice at sentencing, that Mr. Cook was at an extreme risk to recidivate. As the district court said, this bank robbery was the defendant's 13th crime offense involving burglary, stealing, theft, forgery, and so forth. The district court explained all of that at length in sentencing Mr. Cook. So I think there's no question that she explained the sentence thoroughly. At some point, Your Honors, I think this is what we're seeing here. At some point, the criminal justice system just has to say that's enough. I think that's what happened here with the sentence. The sentence was thoroughly warranted, and the district court thoroughly explained it. There's certainly no basis here for showing that the sentence for bank robbery was an abuse of discretion. So we urge the court to affirm. Thank you.
Thank you. Mr. Frederick.
Your Honor, the government comes here today with a couple of assessments that were never stated or really established at the district court level. That being that the government says that he pointed, in fact, a gun at one of the teller's heads 3 to 4 feet away and said, "Stay where you are." None of those statements were ever mentioned in the transcript. 3 to 4 feet away was never that. I guess that's the government's view of the video. When he looked at it himself, none of that was really established. The district court's reliance on criminal history was, yes, Mr. Cook had a long criminal history, but it was viewed a bit skewed, in my view, at the district court level. 13 offenses, but 8 of those offenses were from the 80s, from the Reagan era, when Mr. Cook was 18 and 19 years old. He had actually lived in the community for about 12 years prior to commission of this offense, with that one theft of food from a Walmart in 2020. I don't, and that's, I suppose, counted among those 13. So I think that criminal history is somewhat overstated in this case. This is not harmless error. None of this is harmless error in this case. The district court attempted to inoculate their sentence against remand by making a statement that I think I would give the same sentence if even if I'm wrong on the guidelines, and more or less resting her sentence on the 3553A factors. This court disfavors attempts to inoculate sentences like that, because if you regularly upheld such inoculations, the guidelines would cease to have any meaning at all. They were meant to have meaning.
But doesn't it make a difference here, where the court did more than just say that, or added why under the 3553 factors she would do the same. So it wasn't a throwaway, oh, I would get the same sentence. It was under 3553A, because of your criminal history, because of the nature of what happened here, because of your escalated history, I would get the same sentence. That seems different.
Presumptively, if there's a guideline error under, I think, Gall and Marks, it usually goes back to the circuit court. In cases where it hasn't gone back, where it's been harmless error, are usually cases where the district court imposed a sentence below the guideline range. In one case, it was multiple life sentences. In cases where it was clear that there was not going to be any difference in the sentence. I see my time is up, Your Honors. Thank you.
Thank you. Our thanks to both counsel. The case is taken under advisement. And our final case for argument this morning is United States versus Reyna. Mr. Pennington, whenever you're ready.
Good morning, may it please the court. Good afternoon, sorry. May it please the court. Chad Pennington on behalf of the appellant here, Mr. Jose Reyna. Your Honors, this case represents a narrow, rather straightforward request for relief, but an important one constitutionally. And we ask that this court apply the Second Amendment's plain text to the statute for which Mr. Reyna was charged, Section 922K, unlike the district court, and apply it as Bruin directs. This court should reverse for two fundamental reasons. First, a reversal here and a remand would ensure that district courts, when confronted with the Second Amendment challenge, apply text as directed at the first portion of the Bruin challenge. And second, to ensure that district courts do not consider matters extrinsic to text, such as means and balancing, such as the social utility of a firearm regulation, the investigatory benefits, and even history. History itself, Your Honors, is reserved for the second part of the Bruin test.
I think that misreads Bruin. Very little about the Second Amendment's text will resolve any case without further inquiry into the meaning of that text based on a historical analysis and an analysis of the legal tradition at the time, the background legal tradition that informed the founding generation in adopting the Second Amendment. The text of the Second Amendment itself is never going to resolve any question. So I think you're over-reading that language from Bruin that focuses on the scope question that begins the analysis. The scope of the right needs to be determined as a threshold matter to address arguments, usually from the government, that the regulated conduct falls outside the scope of the right. And we're to examine the founding era history and legal tradition to determine, to answer that question. And then the second step is the government's justification for the regulation. And we now know that that has to be keyed to an analysis of similar or analogous regulations in our history and legal tradition rather than any kind of means and fit kind of a justification as in the First Amendment context. So nothing is answered by the text alone is my basic point. And that seems to be the thrust of your argument.
Your Honor, I would agree that text doesn't control the outcome necessarily under the Bruin analysis. It's text and its history. And the historical tradition of firearm regulation at step 2, that definitely would dispose of a number of firearm regulations, absolutely. But I think the Supreme Court in both Heller and in Bruin stated that when you look at the textual analysis, you apply the ordinary and plain meaning of the text of the Second Amendment, and you apply that to the actual.
No, the court in both cases says that there's an initial question about the scope of the right, and in Heller, what kind of a right it is, an individual right or a collective right. adhering in militia service. That's a question about the scope and meaning of the right. The application questions and the government's justifications for firearms regulations are the second step analysis. So both steps are completely informed by founding era history and legal tradition, and in some cases, history and legal tradition predating the founding era or postdating the founding era. We're not exactly sure, but we're working it out. So maybe you could situate your argument within that textual and history and legal tradition form of analysis at the threshold question about the scope of the right and whether possession of a firearm with an obliterated serial number falls within the scope of the right or outside the scope of the right as a matter of our history and legal tradition.
Certainly, Your Honor. I think there's no doubt that the district courts, to answer your question a more elaborate way, I think there's no doubt that the district courts, they are struggling with Bruin. In our district, there's been a fair amount of Bruin litigation. And what exactly are the contours of the Second Amendment right post-Bruin? District courts are struggling with that. And there is some confusion with what exactly the first step entails as it relates to the second step. Assuming that we do consider the scope of the right as a plain text analysis at step one, what the court has said is the right protects those firearms that are commonly used for defensive purposes. And that was understood within the historical context, because what was commonly used for defensive purposes then it accords with history because it excludes those dangerous and unusual weapons. And dangerous and unusuality in this context, they're referring to military weapons. They're referring to the certain kinds of weapons that were designed expressly for a military purpose. The reason that our challenge here doesn't fall within that particular ambit is because a firearm with a serial number, without a serial number, it remains a firearm. It doesn't affect its functionality. It doesn't affect its range, its capacity. It remains a firearm. It's not the sort of weapon that was designed specifically for military purpose or military capability. So if you apply the common use standard and the standard of whether a weapon accords with the historical understanding.
I'm not following your argument. Are you suggesting that weapons that are appropriate for common defense are excluded from the right?
No, Your Honor. Weapons that are in common use today and then for defensive purposes.
Community defense, military purposes, militia.
Militia. Well, I would say for for defensive purposes within the home, defensive purposes within property.
The right clearly applies to weapons that were in common use by the militia when summoned from the people who possess the right to keep and bear arms for personal defense and for use in militia service. That's the whole point of the militia clause, right? To codify the common understanding that all able-bodied men at the time were expected to muster for militia service when called to do so, and they were to bring their personal firearms for that purpose because there was no standing army.
Certainly, Your Honor.
Right. So weapons that are appropriate for common defense, community defense in the form of militia service are categorically within the core of the right.
I would agree, Your Honor. Those are within the category or the core of the right.
I thought I heard you just say that weapons that are appropriate for military use are outside the right.
That are designed specifically for a military purpose are excluded from the right, Your Honor.
How can that possibly be consistent with the founding era understanding of the Second Amendment right?
Those are the kind of weapons that are understood to be dangerous and unusual, Your Honor.
No, the founding era used that understanding, or the understanding of those sorts of weapons were weapons that were useful only for private or criminal purposes, private conflicts, as opposed to public conflicts, militia service, or were only useful for criminal purposes, not malicious service.
Your Honor,
you've got it exactly backwards.
I'm sorry, Your Honor.
To the extent, I mean, I don't know that this is relevant to your argument, but to the extent that you're arguing that weapons that were useful for military purposes, in other words, militia purposes, were outside the scope of the right. That's exactly backwards.
Your Honor, the weapons that were designed at the time of the founding, the early republic, those weapons had a capacity and they were designed for potentially use of the militia, which was quasi-military. They also had a design functionality intended for use on the frontier, for use at the home. What we're saying is those weapons that were designed specifically and expressly and only for military purposes.
There were no such things back then because there was only the militia. Eventually, there was a Continental Army that was equipped by the government, but the weapons were no different.
Your Honor,
from those that were used by people in their homes.
I think Your Honor, your line of questioning demonstrates why a remand is necessary here, because to flush out these historical sources, to have expert declarations, just like Atkinson's advised, to consider those 5 zones of historical evidence, that's why a remand is necessary here. When we look at
what do you make of Heller that those weapons not typically possessed by law-abiding citizens for lawful purposes?
Your Honor, our position as to that statement in Heller is that is engrafted from Miller. And in that particular case, Miller, the court said that the Second Amendment right doesn't apply to any sort of weapon design. Heller comes along and says that is still good law because that accords with our historical understanding of the scope of the right. So, Your Honor, I would say that is absolutely a valid consideration. I don't think the Second Amendment confers the right to keep every sort of weapon a person may want. But that's a question of history, and that's a question that needs to be resolved as a second step.
But in reaching that conclusion, wasn't the court basically interpreting? You say focus on the text, right?
Mm-hmm.
But I think Chief Judge Sykes makes a really good point, which is you have to interpret the text based upon the historical context at the time, right? What was the thinking of the people at the time as regards the scope of that, right? So isn't the Supreme Court in announcing that, isn't it doing exactly what you want us to do, which is look at the text, and the only way we can figure out what the text means is to consider the historical meaning and the context at the time those words were used. It seems to me that what you're asking us to do in step 1 is precisely what Chief Judge Sykes thinks we should do with regard to, and I think we should do with regard to defining first the scope of it.
Your Honor, to answer your question, I think that
it's hard, it's nearly impossible to figure out what the words mean without reference to the historical context in which those words were used.
I would agree, Your Honor, and that's where we can go to the second step of Bruin. The Supreme Court in Bruin did state that when you look at the text of the Constitution, the Second Amendment specifically, you apply its plain and ordinary meaning, and the outer limits of the right based on the textual meaning that's defined by history.
Ordinary meaning at the time the words were used, right? And so then we have to figure out, well, what was that plain and ordinary meaning at the time the words were used? And for that, we have to refer to the historical context.
To define the scope of the right, correct, Your Honor.
To define what those, to better understand what was meant by those words, by the text.
Your Honor, I think to answer your question as it relates specifically to the district court's decision here, not necessarily discounting that there's a role for history to ground or more of the constitutional text at step 1. What I don't think step 1 permits is the type of balancing the district court did here. What kinds of weapons are typically possessed or what is commonly possessed. That implies some metric of measurement, some quantum that you have to.
Does Bruin say, though, that we have to look at, based on what Heller did, that we have to look at the type of weapon that law-abiding citizens typically possess at the time to determine what the scope of the right is?
Your Honor, that's correct. I would say that could be fit within the second part of the Bruin analysis.
That's how we define what the scope of the right is, by looking again at what a law-abiding citizen would have used back at the time.
Well, I don't, Your Honor, think that we could look at necessarily what a law-abiding citizen would have used back at the time of the founding as dispositive. Bruin specifically says that the protections as to weapons apply to the weapons in existence today, just as they existed at the time of the founding. I would say that, Your Honor, the point I was trying to make earlier, Judge Sykes, is there's the common use standard. And in Heller and in Bruin is reiterated, The right protected those weapons that are in common use today for the purposes of self-defense. And that standard exists because it excludes those weapons which are dangerous and unusual. Those weapons that are dangerous and unusual, those are the ones that fall outside the scope of the Second Amendment protections, because that accords with the historical tradition. So you could use that.
That might be true, but it doesn't mean just those. If they're not dangerous and unusual, but they're not in common use, they don't fall as well.
Your Honor, the Supreme Court of Bruin seemed to suggest that common use, what excludes something from common use, is its dangerous and unusuality based on Miller.
I don't read anything to limit it to just dangerous weapons.
Or dangerous and unusual.
Dangerous and unusual.
Certainly.
There's nothing that said that common use equates with what is not dangerous and unusual.
Well, if it's common use, Your Honor, then it's not dangerous and unusual. But that, what the court is saying in Heller and Bruin is specifically that the right protected is those weapons that are commonly used for defensive purposes. And the way that you gauge that is by examining the historical limits. And in this particular case, the district court engaged in what is typically possessed by law enforcement, or pardon me, what's typically possessed by law-abiding persons. That's not a textual analysis. That's getting into the weighing of the historical evidence. And I agree, if we remand to step 2, district court may ultimately find that the law is situated in the history.
Do you think we define step 1?
You're right. I think we define step 1 as the Supreme Court says you do, and that is you look at the Second Amendment's plain text and you apply it to the individual conduct at issue.
The Second Amendment's plain text answers 0 questions in real cases.
I understand the court's
We
concern.
know that it's an individual right, not a collective right, and it applies against the states. That's all we know so far. The rest is worked out through historical analysis and an analysis of what's consistent with our legal tradition, both as regards the scope of the right and as regards the limits on the government's ability to regulate it. That's shorthand for the 2 steps that Bruin described.
Your Honor, may I briefly conclude? The Second Amendment says what it says. It provides the operative clause a right to keep and bear arms. That's what it says. The limits of the right, those are defined by history, and that's a Bruin step 2 analysis. Thank you, Your Honor.
Thank you. Mr. Holler, good afternoon.
Good afternoon, Your Honors, and may it please the court, David Holler on behalf of the United States. The Second Amendment permits a legislature to require the serialization of firearms and equally permits it to ban interference with that scheme. The test is set forth in Bruin, which the court in Bruin said was completely consistent with Heller, is 2 parts, as this court knows. And the first question is, does the Second Amendment's plain text cover the conduct? The second step is, if it does the law square with the nation's tradition of regulations? As explained in our brief, the government believes we win on both parts of the test, but the court need not reach the second part of the test, and the district court did not reach the second part of the test, because the government prevails on the first part. And I agree that there is a lot left open and opaque by Heller and by McDonald and by Bruin. Some of those questions may be resolved by Rahimi. Some of them are going to be resolved by these courts. But I do think that there is a reasonable explanation of how the court interprets, the Supreme Court interprets the first step of the test. And the clearest indication of that is on pages 622 through 627 of Heller, where the court explains the holding of Miller and explains how that holding is consistent with Heller and therefore also with Bruin. And then its ultimate explanation of why the arms that were at issue in Heller did come within the text of the right, while sawed-off shotguns, which is what was at issue in Miller, did not come within the right. So Heller stated that the Second Amendment confers an individual right to keep and bear arms, though only arms that have some reasonable relationship to the preservation or efficiency of a well-regulated militia. It further stated that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, such as short-barreled shotguns. And it went on to state that the important limitation, this is the step 1 limit, this is on page 627, was what it did protect were the sort of weapons in common use at the time, And that holding that it was weapons in common use was supported by a historical tradition of prohibiting the carrying of dangerous and unusual weapons. That's the only mention in Heller of dangerous and unusual. And the only mention in Bruin is essentially a follow-up quoting Heller. So dangerous and unusual supports what the text of the Second Amendment means. And what the text of the Second Amendment means is, were they in common use? So that's the question that the court has to ask, is and then what the court goes on to say is, we're not asking, were handguns in common use in 1791? We're bringing everything to a reasonable analog. So we're asking, in 2023, are the weapons that this particular legislative scheme is prohibiting, are those in common use? And it's not asking in general, are shotguns in common use by law-abiding citizens? It's asking, are sawed-off shotguns in common use? And the answer is no, they're not. And therefore, Heller said, Miller is right. Sawed-off shotguns are still out. We're not suggesting that sawed-off shotguns are okay just because shotguns are in common use and because the government can't prove that in 1791 there was some law that prevented people from sawing off their shotgun. So that's the test. So then if we apply that test to obliterated serial numbers, the government would submit it comes out the same way as sawed-off shotguns. These are not weapons that are in common use, just like sawed-off shotguns are not in common use. And these weapons are commonly used for criminal purposes. They are used by criminals because it is then possible to ditch your firearm after you commit a crime and not have it traced back to you. That's what Marzella said. That's the reasons why these statutes have historically been implemented. And so for all those reasons, deserialized firearms, just like sawed-off shotguns, are not commonly possessed by citizens for law-abiding citizens for lawful purposes. And I would say that that's the analysis that essentially decides this case. I think that's essentially the analysis that decided this case for the district court.
You say that we look at weapons used today in 2023. What role does history play then in that first prong?
Well, I think history is essentially was used by the Supreme Court to define what weapons fall within the definition of protected arms. So the Supreme Court, I think, has sort of done the historical analysis at the first step, and it hasn't done the historical analysis at the second step, which is why the lower courts are being tasked with all of that burden. But I mean, I think that's
historical analysis is the coming up with the common use, and we don't have to do anything else at step one in terms of history.
I don't think that the court really does have to do anything else with step one at history. I mean, this is just the general nature of how the legal process proceeds, right? I mean, the courts in general look at the law and look at what the constitutional provision meant at the time. And then if the Supreme Court hasn't done it, that's what the courts of appeals or the district courts do. And then once that historical purpose has been determined, then that's the law. So, and to be clear, I think that we are still at step one having to look at history in defining what the people is, which is what most of the cases that we're now looking at are focusing on. Are felons part of the people? Are people under indictment part of the people? We kind of need to look back at history to do that. And had the Supreme Court not done in Heller what it did to try to define what arms are, this court would be doing the same thing. But the Supreme Court's done a lot of that already.
But Heller was not the court's last word on the scope of the right as it pertains to what sorts of arms are protected or within the scope of the right. The amendment doesn't protect guns, it protects people, just like the Fourth Amendment doesn't protect places, it protects people. But that wasn't the court's last word on the scope of the right as it pertains to questions about what form of weapons, what kinds of arms are categorically protected and what kinds may be categorically unprotected.
I agree with that. So if there was some evidence that firearms with obliterated serial numbers were categorically permitted back in the 1790s, then I mean, that would be relevant evidence. But there's no evidence of that. Serial numbers weren't really placed on firearms until about the 1840s. And to the extent that we have historical evidence on that point, we do have the statutes from the early 1800s involving, barrel proofs and barrel markings, and nobody suggested that any of that was unconstitutional. We had marking of gunpowder, which was essential to use your musket. If you didn't have gunpowder, you didn't really have you didn't really have a weapon. You didn't really have an arm because your musket was useless. So, and marking of those things was permitted. Commercial regulations were permitted. To the extent one looks at the militia context, there were censuses and listings, by hand of the firearms that were going to be used by the militia.
Right, but what were the purpose of those regulations when militiamen were expected to show up and present their arms for inspection and marking? That doesn't map on to the purpose behind the serial number obliteration ban that's being enforced here.
Well, it doesn't perfectly map onto that ban. I certainly agree with that, but it's still a relevant analog. I mean, to the extent that it doesn't map onto that ban, it's because we didn't have detective agencies. We didn't have the ability to trace firearms. I mean, to some extent, firearms in American firearms, at least in the 1790s, were all unique. They were all individually crafted by gunsmiths. So, and transportation was hard. So if you recovered a gun, to the extent any early constable or the private citizens who were, or the state actors who were engaging in those kinds of activities, you would be able to identify the firearm. You'd be able to identify by its characteristics who had made it. You would probably be able to go back to that person and identify it. It was only with the rise of mass production that you would even need to serialize firearms. And once serialization came into play, everybody seemed to think that it was fine for that purpose. There's no evidence that anybody ever thought that this was a problem that infringed on anybody's Second Amendment rights. So for all of those reasons, I think that there are relevant analogs that do exist. I mean, Heller and Bruin sort of said, look, there were common issues regarding possession of firearms, and so we look at those analogs, and they didn't permit the wholesale banning of keeping firearms in your home, and they didn't keep the carrying firearms on your person. But there are limited classes of arms that can be restricted. These are arms that are not in common use, and it isn't an infringement on anyone's rights to, at least as that would have been understood at the time of the Second Amendment, to require marking of your firearm.
Arms that were not in common use or are dangerous and unusual.
Right. One or the other, but firearms with obliterated serial numbers are not in common use. They are unusual, and I don't know.
And by dangerous, I mean all firearms are dangerous. So I think by dangerous, that's shorthand for adaptable to criminal purposes, because that was always thought to be regulable, right?
I think that that's true, Your Honor. I mean, I think the defense in many of these cases has wanted to turn dangerous and unusual into unusually dangerous, and I don't see that anywhere in any of the Supreme Court cases.
No, and I would agree with that. But the regulation at issue here, or the criminal statute at issue here, prohibits possession of a firearm with a filed off serial number, and those firearms, you argue, are not in common use. They're only used by the criminal element. Which strikes me as satisfying both components of the Supreme Court's description of the types of arms that would fall outside the scope of the right, those that are not in common use and that are dangerous and unusual in the sense that they are adaptable and used by the criminal element.
I would agree with that, Your Honor. They're not common. They're not in common use. They are adaptable for the criminal element. So
as a general matter, by determining the scope question, the threshold scope question, at a higher level of generality than we describe or define the second step question, which is the extent of the government's ability to regulate. There we have to look for something that's meaningfully analogous. Relevantly analogous, to use the court's words in Bruin. But the first question is a different sort of analogic reasoning.
It appears to me that it's at a higher level of reasoning. It's bit more of a quick look or a higher level. It's not asking. I don't see anything in Heller or Bruin suggesting that on the first step you're supposed to be doing that deep of a historical dive and trying to create an exact match to some prior regulation. You are doing that at the second step, and we have at the second step offered the best analogs that we can to those tests, the gunpowder regulations, the trade regulations, the barrel markings, all of those things. And I think, therefore, we would prevail at that step as well, but I don't think the court needs to get there.
Well, what we're really looking for is some historical information or information from our legal tradition that would give meaning or content to the scope of the right, as opposed to looking for a specific analog to the modern day regulation. And that's a little hazy. And we're all sort of slipping into trying to read the Supreme Court's opinions in this area as statutes, which they shouldn't be read as statutes. They're opinions that contain common law-like reasoning, and that's leaving us with uncertain guideposts to how to proceed. If we have to get to step 2, if we say that this statute, that the government hasn't carried its burden of establishing that this statute regulates conduct that falls categorically outside the scope of the right. And I know you have a burden of proof argument in your brief. If you want to spend a minute on that, go ahead, and then address step 2.
Sure, Your Honor. Well, the court obviously has not stated who has the burden on step 1. The only guidepost, and I am sure the Supreme Court will give us guideposts. The first point I would state is I don't think that the burden matters here. I think even if the burden were on us, I think we have met our burden. But to the extent that the court feels a need to establish the burden on step 1, the court compared this to the First Amendment. In the First Amendment context, it is the defendant's burden or the challenger of the statute. Most of these cases obviously arise in the civil context. It's the challenger's burden to establish that it falls within the right, and then it's the government's burden.
Actually, that's only in the expressive conduct line of cases, which are that's the case that you cite from the 1980s. If the challenges, or if the government's regulating conduct and the individual claims that my conduct was expressive in nature, then that individual bears the burden of establishing that his conduct is expressive in nature and therefore falls within the scope of the right. If the regulation is operating on speech itself, then it's the government's burden all the way down.
Well,
there doesn't have to be a prima facie showing that by the claimant.
I mean, Bruin is a bit of a new case, so we're trying to map this back onto the First Amendment, Your Honor. But the way that we view it is the First Amendment regulates speech, and so it's the defendant's burden to show that it's speech. So does expressive conduct fall within speech? So that's the question. Analogously, do firearms with obliterated serial number fall within arms? That's where we analogize. And then once they've shown that step 1, then agree the burden falls on us. So in most First Amendment contexts, there's not going to be much dispute that the claimant was speaking. So we don't have a lot of First Step cases. And we're probably not going to have a ton of First Step Act cases in the Second Amendment context once the Supreme Court gives us a few more guideposts as to exactly who are the people and exactly what is an infringement.
Yeah, but even in the Supreme Court's more modern First Amendment cases, in particular, the violent video games case and the Crush Videos case and those Brown and Stevens and so forth, those place the burden squarely on the government when the government is arguing that this conduct falls categorically outside the scope of the First Amendment right. The court has, and those cases are from the last 10 years, the Supreme Court has always held the government to the burden, or assigned the burden to the government on that threshold scope question, the categorical question about whether this is in or out, and then to the whatever doctrinal analysis follows.
Once they've determined, as I think that they have, that kind of expressive conduct is speech, then of course the burden is on us. So again, I think that's just at that early stage. Again, I think either way, I think if the burden falls on us, we've met our burden here. I don't think that issue really needs to be resolved in this case.
Mr. Heller, is there any reason we should wait until after the Supreme Court rules in Rahimi to reach this case?
I think my answer to that question would be that if the court agrees with the district court's analysis and our analysis that this is a step one case, then no, it should not, because I think the court has laid out that analysis sufficiently to define, for purposes of this case, what arms is. Rahimi involves a flat out ban. So I don't really think the Supreme Court is going to extensively flesh out anything about what an arm is or what it means to infringe the right to arms. There's no doubt that the regulation in Rahimi G8 infringes the right to arms. I don't think the Supreme Court's going to say anything relevant to that issue. If the court were to decide that we do not prevail, the district court was incorrect, and to go on to the second step, I think it would be up to this court. I think the Supreme Court might well discuss that second step in some detail, because that's the step that has predominantly caused confusion in the lower courts. So if the court were to go on and reach that second step, I think our historical analogs provide strong evidence, and my view would be that we prevail whatever the Supreme Court is going to say, but I certainly could see this court wanting to wait. Thank you, Your Honors. We'd ask the judgment be affirmed.
Mr. Pennington.
Thank you, Your Honor. The rebuttal, just note that the Supreme Court has said that the Second Amendment applies or extends prima facie to all instruments that constitute a bearable arms, even those that are not at the time of the founding. A firearm without a serial number would constitute a bearable arm. It would fall within the first step of the analysis, Your Honor. Also, I think the government said that we are trying to—
So would machine guns.
Potentially, Your Honor, and their exclusion, if it's grounded in history, that would be the test. I would offer—
See if the Supreme Court really meant it.
Certainly. In finality, with respect to whether the step one consideration can consider dangerous and unusual standard and other forms of history, I would offer the patent case out of the District of Nebraska. That's 2023 Westlaw 6230413. That specifically stated that the question of dangerous and unusuality, that's reserved for step two, which is exactly our argument here, Your Honor, that this is a straight textual analysis. We would ask that you reverse.
Thank you. Our thanks to both counsel. The case is taken under advisement, and that concludes our calendar for today. The court is in recess.